Okay. Good morning, everyone. The time schedule is full also today. There are a lot of speakers. Welcome back. Thank you for staying with us also today for the second day of the Young Penalist Symposium. Thank you also to those joining online. I think we can start this second day. Yesterday was a great day, very interesting and engaging presentations. Today will be very important also to be very strict with the timing because there are a lot of speakers also today, so please keep the time of 10 minutes as agreed. I will not take you more time. Thank you again. I will give the floor to my mentor and the president of the Italian Gruppo AIDP, Professor Antonio Gullo, who will introducing the topics of today. So thank you, Professor, for being here with us.
Thank you very much, Emanuele. It's a great pleasure to be here also today. Yesterday really was a great day because it was a unique opportunity to really participate in a very stimulating debate. I would say that all the speakers really were capable to highlight the main issues concerning the very interesting topics covered by this symposium. And also the debate was very stimulating, as I said. And really, congratulations to Emanuele for the great organization. And I would say, which is also very important, to give us the possibility to stay together also in the evening. So it was the dinner also a great opportunity to share opinions and also to create network, which is something, in my opinion, very, very important also for the future. So to continue working together. So we can say that the first day has fully met our expectations, and I am sure that also today we will have the possibility to hear very interesting considerations, and it is also a full day. Therefore, I will say something briefly. So my introduction will focus on some points which will be more discussed later. Yesterday, you covered a lot of topics, from the issues surrounding non-conviction-based confiscation to the use of non-criminal instruments in the fight against organized crime, and to the exploration of the different economic dimensions of organized criminality. So many topics of crucial importance, considering also the new trends of criminal law, also starting from some traditional issues, and a lot of problems connected to the protection of fundamental rights. I've been entrusted with the task of introducing this second day of discussions, and as I said, I am confident that also today we will have the possibility to speak about very interesting issues. Today's symposium may be ideally divided into broad thematic sessions. In the first, we will host the final two panels of the conference's second session, devoted to the economic dimension of organized crime and to the issues of substantive criminal law and corporate criminal liability. In the second, we will have the pleasure of hearing different and highly engaging papers on themes relating to criminal procedure and international cooperation, structured across 3 dedicated thematic panels. In this introduction, I will therefore seek to offer a few remarks on the topics that will be examined during today's proceedings, highlighting some of the thematic and research lines that, in my opinion, are particularly interesting and significant. Let us begin with the 2 concluding panels of the symposium's second session. The first will address issues of crucial relevance and I believe of particular originality. It will provide an opportunity, first of all, to come back to the topic of confiscation, which was extensively examined yesterday and which will today be revisited through papers offering fresh perspectives on the highly controversial legal instrument. Asset recovery indeed today takes on different forms and institutional arrangements whose structure, underlying rationale and legal nature are constantly evolving and inevitably influenced by the broader regulatory context in which each provision is situated. This in turn complicates any conceptual reconstruction, and it is often difficult to distinguish between the declared and the underlying functions of these illegal measures. Thus, confiscation aims to prevent future criminal conduct, discouraging the perception that crime pays, or it is primary purpose to punish the perpetrator or suspected perpetrator of an offense, imposing an economic sacrifice in addition to the principal penalty. Or alternatively, does confiscation serve solely to restore the economic balance disturbed by the commission of a crime? The answer can only depend on the specific design of the individual legal provision, on the nature and value of the assets confiscated, and on the applicable safeguards. Yet, even these preliminary questions, I believe, already convey the complexity of the challenge before us. Also, yesterday, we had the possibility to hear different perspectives concerning the nature of confiscation, and also Professor Mongillo in his introduction, Francesco Mazzacua, and I think it's a crucial point because we know that in the last years also our Constitutional Court said a lot about the nature of confiscation, and it was interesting hearing that if we think that the nature is the same, there is a problem concerning the way in which the different forms of confiscation are designed, are shaped. The symposium will touch upon a complex issue, the criminalization of the use or even mere possession of funds suspected of illicit origin as a strategy to combat organized crime. Such measures are in different ways contemplated in certain international instruments, but appear highly problematic from the perspective of a criminal law system sensitive to fundamental rights and guarantees. This is another point, in my opinion, which is very interesting because we can, if we look at international regulation, also, for example, in the field of corruption, if we think about the proposal of the directive, we can really see some provisions which are which goes in this perspective, and I have to say that it is something which is very problematic because also in the past, as Italian system, we experienced problems concerning these measures in terms of the constitutionality of the compliance with the constitution of this measure. We will then venture, so to speak, into frontier areas. First, we will consider the prospects for applying restorative justice programs to cases of organized crime, a clearly dedicated subject, yet one which I believe is particularly interesting from a forward-looking perspective, given the challenge of designing and implementing tools that can foster dialogue between perpetrators and victims in contexts often marked by significant violence and with profound emotional impact, not only on the individuals directly affected, but also on their broader communities. And I would say this is another point which is very interesting. So I think that there are a lot of areas on which I think we can work considering the role of restorative justice. This is, as I said before, a frontier area, but I think that it is worth to do some considerations about this perspective. Another equally compelling topic concerns the protection of whistleblowers who report irregularities in cases involving organized crime. Legal systems, such as the Italian one, have for some time developed the cutting-edge mechanisms to safeguard witnesses and collaborators, with rules designed both to ensure the reliability of their statements and to protect them effectively in all aspects of their personal and professional lives, including through financial support measures. It is therefore necessary to consider whether and to what extent these provisions should be coordinated with relevant measures in the private sector, particularly in relation to whistleblowing, especially where gaps in protection may be identified. It is interesting, this coordination between two different systems from one perspective, but if we think about the Italian legislation on collaborators in the field of organized crime, it is important to align the different disciplines. Other presentations will focus on the extent to which a certain manifestation of organized criminal activity can be addressed under the Rome Statute of International Criminal Law, and what opportunities, as well as challenges, arise from classifying organized crime offenses as predicate crime capable of triggering corporate criminality. What concrete contribution can criminal compliance make within a lawful business context to prevent involvement in organized criminal operations? Or are such provisions aimed solely excluding from the legitimate market any enterprise that irreversibly under the control of criminal organization? Yeah, this is interesting because also in this case, if we look at the Italian system, our legislative decree, there are some provisions which are dedicated to organized crime, but they are more oriented to the perspective to exclude this organization from the legitimate market. A paper addressing the multiple intriguing interconnections between mafia activity and corruption will then close the second session of the symposium, which I believe has explored the economic dimension of organized crime in all its most complex and compelling aspects. The symposium will then move on the scientific reflection on criminal procedure and international cooperation, which particularly in the field of organized crime and with reference to the Palermo Convention has provided a very important ground for the development of even more sophisticated legal models. The first panel will examine the digital dimension in the fight against organized crime, which often involves the application of special rules, not only in substantive criminal law, but also in criminal procedure. For example, the provision allowing remote participation in proceeding by detainees considered particularly dangerous. Several presentations will focus on the one hand on the complex issue of digital evidence, addressing the challenges that arise in the context of international cooperation frameworks. Consider, for instance, the recent high-profile mass hacking cases, which have facilitated numerous prosecutions for serious organized crime, but at the same time raise questions regarding procedural safeguards for individuals subjected to such wide-ranging investigations. The discussion will then come back to another crucial point, the role of the European Union in combating organized crime. Beyond the considerations of the activities of established bodies such as Europol, many presentations will focus on the role of the European Public Prosecutor's Office, EPPO, whose establishment represents one of the most significant innovations, as we know, in European criminal justice in recent decades. Frontier issues will be examined, including the relationships between EPPO proceedings and administrative freezing measures, the difficulties EPPO encounters in combating organized crime in participating member states with the rule of law deficiencies, and more generally, the challenges associated with forms of international cooperation in transnational organized crime involving the European Union. The first panel will complete the overview of the most pressing issues in criminal procedure, focusing on further experiences of international cooperation, as well as on the interconnections between anti-money laundering enforcement and organized crime, which, in my view, raise important practical and legal questions, alongside issues related to long-term surveillance in such proceedings. The symposium will then conclude with a paper on the use within penitentiary law of the so-called hard prison measures for offenders convicted of organized crime offenses deemed most socially dangerous, which I believe provides a highly effective completion to the picture of the most current and pressing issues in the fight against organized crime today. Special rules applied in this area indeed, following the logic of the so-called double track system, affect not only substantive and procedural criminal law, but also penitentiary law, imposing particularly severe conditions on such offenders, aimed primarily at preventing contact with the outside world and with other members of their criminal organizations. This rule, however, requires careful consideration of the impact of fundamental rights and once again highlight the difficulty of balancing social defense imperatives against such worrying criminal phenomena with the protection of individual guarantees. So, as also in this case, in the Italian system, we have experienced this double track since many years ago, and for sure a point which is very interesting, it's an integrated approach, because if you would like to have an idea about, I would say, with inverted comma, the pressure of our system against this criminal phenomenon, we have to think about, as I said before, the integration between substantial criminal law, criminal procedure law, but also penitentiary law. But at the same time, we know there are a lot of also decision of the European Court of Human Rights with different, I would say, results concerning the compliance of these rules with the fundamental rights protected by the European Convention of Human Rights. So this is a point which is very interesting. And also in this case, I would say that this symposium was able really to cover all the interesting topic, but also to look at this topic in a new perspective, which is also very interesting, and also to combine the different pillar of the criminal strategy in a broad sense to fight this phenomenon. Now we are speaking of organized crime, and also the interconnection between organized crime and other crimes, which are usually, or traditionally at least, considered very with a strong link with organized crime. I was speaking before about money laundering. So this, I believe, has represented and will continue to represent the red thread running through this exceptionally engaging symposium. I am sure, as I said, that also today it will be an opportunity really to share opinions and to analyze all these problems. And I think that, which is also something very important, in a very stimulating atmosphere, and also, I would say, in a good atmosphere from I would say, the feeling that every one of us can have participating in so interesting symposium, but also cases in which there is the possibility to stay together, people coming from different generation, and I think it is really a great enrichment for, in my opinion, everyone who every participant. So congratulations again to the organizers and to you, because this symposium and the result we are achieving are very linked to your capacity to say something interesting and stimulating, and also to participate as member of the AIDP community. And it is really probably the most important thing. So thank you very much, and I am very glad to open also this very full day. So Emanuele was able to put a lot of people, but really also yesterday it was my congratulations, because everyone was able to say a lot of things in a very short time. And I have to say that it was not a penalty, not a sanction to be part of this symposium, because also the last session yesterday was very interesting, considering a lot of issues covered, and also that interconnection yesterday also between digital issues and organized crime was also something partially new and very interesting. So today is Saturday, so I hope that Emanuele at a certain time will give you also the possibility to visit a bit Rome, but okay, I'm really very glad. Thank you.
A few seconds and then we can move to the first panel of the day. Yes. Okay, the first panel of the day will be introduced by my colleague of the AIDP Young Penalist Committee, Yuto Yokohama. Yuto, good morning, welcome. And the panel will be chaired by Nicola Recchia, who is tenure track assistant professor of criminal law at the University of Trieste. So Yuto, the floor is yours. Thank you for joining us, and please.
Thank you. Do you hear me? Okay.
Yes, yes.
Thank you. Good morning, everyone. I'm Yuto Yokoyama, assistant professor at Shinshu University, Japan, and also a member of Young Penalist Committee of AIDP. Welcome to the first panel of the day, panel 4, organized crime between asset recovery, restoration, and protection of whistleblowers and witnesses. I wish I could be with you in Rome, but it's my pleasure to briefly introduce our chair and distinguished speakers of this session. Our chair, Dr. Nicola Recchia, is a senior researcher in criminal law at the University of Trieste. Within the AIDP, he served as a member of Young Penalist Committee and now sits on the scientific committee. And we are honored to have 4 presenters today in this panel. Dr. Ana Isabel Garcia Alvarez, assistant professor at the University of Salamanca and visiting professor at the University of Palermo. And Dr. Maria Quintas Perez, assistant professor at the Pontifical University Comillas, and Mr. Alfredo Junior Dalize, PhD candidate in Peace Studies at Sapienza University of Rome. And finally, Ms. Maria Di Macho, PhD candidate in criminal law at the University of Bali, Aldo Moro. So we have Chair Dr. Nicola and 4 members. Now I'm pleased to hand over to our chair, Dr. Recchia, to guide us through the session. Thank you.
Thank you very much, Yuto, for your kind word of introduction of this panel. And first of all, let me say that I'm deeply sorry that I wasn't able to be here yesterday. I've heard it was a wonderful discussion that you had yesterday, but unfortunately I had some other commitments that I could not skip. And so sorry for that. And before I start, I will try to be as brief as possible, but I really need 1 minute to thank the Young Penalist Committee, of course, everyone that is here and online, and especially Emanuele, because we know that the one that is organizing in his own university has to have the biggest burden on the organization. So thank you very much, Emanuele. I'm so happy that you are continuing so good and much better than we did the work on the Young Penalist Committee. It was in Rome that I was elected in 2019 in the International Young Penalist Committee, and I'm so happy to be here again, in a sense, in Rome, to go full circle and to see that you've managed in less than 1 year, actually, from your election to have such a wonderful first conference of your cycle, let's say, as we say in the AIDP terms. And for everyone participating in this conference that is not already a young panelist, I will say that it was for me a young panelist conference like this one. It was, I don't remember which number of symposium, it was in Munich, and was for me the first experience getting to know the young panelists and the AIDP. And so for me, it was the first time getting to know this association that later was a big part of my scientific activities and experience. And of course, thank you very much as well to Professor Gullo for his guidance, his enthusiasm always for the activities of the young panelists at the international level, as you see now, and as you have seen maybe in Bologna, when we organized another international symposium of the young panelists. And of course, for the ones of you coming from Italy, you know, the warm support that we always had from Professor Severino before and now from Professor Gullo for the activities of the young panelists as well at the national level in the Italian group of the AIDP. And last but not least, thank you very much for this honor by the UnitelmaSapienza, Professor Mongello, having the possibility to fund and organize such a big event. It's not easy in this time to do so. So as I said, I will try not to give an introductory speech, also because we had such a wonderful and rich presentation already today by Professor Gullo. And so I will try to reserve a little bit of my time maybe for the discussion later. I wanted just to touch on one point, maybe if I can give my 2 cents on the topic of the conference. I see we have, let's call it a functional perspective on organized crime. Mainly in this conference, we are looking at how we can fight better organized crime. We are looking at different types of reaction, from confiscation to illicit enrichment. We will hear that about just in a few minutes now. And of course, the focus is on how we can fight better organized crime, and maybe that would be my preferred choice as well, of course, how we can guarantee the fundamental rights, the criminal law fundamental guarantees in doing so. But let me try to give maybe a different perspective on the topic, a more critical one if you want. I've been too much in Frankfurt not to do so. And I think that one problem that we have now is the definition itself of organized crime that is getting out of our hands. And I think that our first role would be, as criminal law scholars, to rein the discussion on what is organized crime. I mean, we have, let's start by an example that is all over in the news internationally, the Puff Daddy trial in the US. We have some prostitution-related offenses, some sexual assault-related offenses from a pretty famous rapper, I get. And we have RICO charges as well. So the charges that were delved into by the jury were also of organized crime. We have in Germany a big discussion on Clankriminalität, and maybe I would call it a little bit of moral panic about Clankriminalität. And I think that racism and xenophobia have not such a limited role in fueling this discussion on criminal activities that are similar to criminal activities by other members of our society, as criminal activities that are different in kind from the other ones that should be called Clankriminalität, that should be called organized crime. So I see that organized crime may be a way of performative language of stigmatizing certain type of criminal activity without maybe grounds to do that. We see that in Italy as well, that so many criminal activities get added every couple of years to the list of what is organized crime and what gets a special treatment in our jurisdiction. So I think that we should really be wary on the definition of organized crime, what counts as organized crime. And we have the same problem, actually, I think even a more pregnant one, also in the so-called mafia type organized crime in Italy that gets even another stricter discipline in Italy in comparison to normal organized crime, if you want. And I find a little bit strange that I get the most interesting aspects that I've read on the mafia-related crimes in Italy doesn't come from our work at university, but it comes from a journalist investigation that was published in an English newspaper and then later translated into Italian and was published in the newspaper L'Internazionale, the International, if you want, and from two journalists, an English one and an Italian one, that looked at some trials that are going on in Sicily, especially about Nigeria organized crime and Nigerian mafia. And I was pretty shocked at the level of, I don't know, difficulties, let's say like that, or the way of creativity about establishing the mafia type of these kind of organized crime that is active. I think that maybe, of course, we have to talk about confiscation, restorative justice, and whistleblowing, but we should really keep a look on what we call organized crime, and maybe be wary that there is as well a big discussion to have about, first of all, what we call organized crime, and then even before going on the discipline of these phenomena. I've spoken much more than I wanted to, so sorry for that as well. And I will give immediately the floor to Anna Isabel for the first speech of this panel. Thank you very much, Anna. Can you hear us? Can you? You have some problem with the slides, maybe? Can you switch on your microphone?
Yes.
Yes, now we hear you. That's already a start. Let's see. I don't know if you have some slides that you want to share, but I'm sure that you can do that without as well. Now we don't hear you anymore. You switched off the microphone, I guess, again. We could hear you before, but then the microphone was switched off again. If you can try to switch it on again. Should we give you a minute and then we skip to the other presentation and we come back? Is that a solution maybe? We give the floor to Maria and then we circle back to you? No. Ma sì,
non ti sentiamo.
o se abbiamo
È disattivato.
un WhatsApp per dirle.
Okay. I have said that.
Now we can hear you. Thank you very much.
Okay. Good morning, everyone. As has been said before, my name is Ana Isabel Garcia Alfarad. I'm an assistant professor in criminal law at the University of Salamanca. I have prepared a slide of presentation, but I can't share with you. Sorry, but I don't know because, but I see, I share my presentation, but I can't really share it. So First of all, I would like to start my lecture or my presentation by thanking the organizer for the opportunity to participate in this event and to do so online. Today, I'm here to talk to you briefly, I promise, about economics of punishment, confiscation as an expression of a new criminal paradigm. Phenomena such as economic liberalization, the existence of areas of free movement of capital, goods, people, globalization, among others, favor the increase in the economic and political power of companies, as well as the commission of crimes, especially in the economic sphere. In general, it is considered that corporate crime is characterized by its impunity. Criminal law focuses effort on the punitive element, on punishing the perpetrator, overcoming obstacles such as machine of Roman law, societas delinquere non potes, or the presence of plutophilia or a criminal law of the friend. However, establishing only the criminal liability of legal person is not enough, because companies continue to maintain their objective, their purpose, to profit from their crime. Consequently, enforcing penalties is as important as ensuring the recovery of assets. Emphasis must therefore be placed on the fact that companies lose assets and profits derived from criminal activities in order to prevent other companies from considering the commission of crime as a way of enriching themselves. This aspect is clearly supported by most criminological theorists. For example, rational choice, social control, routine activities, and so on. Confiscation can help strengthen confidence in the justice system by showing that perpetrators are not above the law, that crime does not pay, that it does not go unpunished, and that under no circumstance perpetrator will be able to enjoy the proceeds of their crimes. Confiscation has gone from being an ordinary confiscation to value-based, extended, third-party, not conviction-based confiscation in rare measure, highlighting the expansionist trend in which criminal law is currently immersed. It is a clearly preventive criminal law increasingly based on presumption. However, every light causes or generates shadows, and even the predominance of efficiency leads to the violation of human rights framework and procedural guarantees, because presumptions are established, the burden of proof is reversed, the presumption of innocence or the right not to testify against oneself are violated, or a causal relationship in criminal law is relaxed. But the question is confiscation effective? Should efficiency be sought over guarantees? There are significant difficulties in implementation. The identification of illicit assets, their mobility, the presence of virtual currency or cryptocurrency, which make them difficult or impossible to trace, the existence of different national jurisdiction, and so on. The question arises again as to whether confiscation is truly effective. Several official documents attest to its effectiveness, and efforts are being made to increase it. However, actually, a 2023 Europol report estimates that the amount of assets that police service managed to seize from a criminal network remains less than 2% of the annual proceeds of organized crime. The remaining 98% continues to fuel organized crime. It seems, therefore, that we are talking about theoretical effectiveness rather than practical effectiveness. Finally, I'll present the main conclusion of this research. First, current organized, corporate, and transnational crime constitutes one of the main challenges to security and stability of a state. Second, the effective implementation of asset recovery mechanisms can contribute not only to the fight against corporate crime, but also against corruption, for example. Confiscation is an essential tool to ensure that criminal activities are not profitable. However, as Beccaria said, reliable and effective enforcement is necessary. The alleged preventive effects cannot be achieved merely by providing for measures in law, in legislation that are rarely actually applied, revealing the presence of a mere symbolic criminal law, a weakened criminal law, in that it contradicts and violates its warranties and legitimizing a principle in the interest of non-existent effectiveness. Third, states remain anchored to the principle of territoriality, simply forgetting that we live in an era of globalization and in a digital age, and that almost nothing develops exclusively within the borders of a single state, including crime, of course. It is therefore essential to increase international cooperation. If we are facing a global phenomenon, the response must also be global. Fourth, and finally, it is necessary to reflect on whether the flexibilization and functionalization of criminal law expansion for the sake of greater effectiveness is truly worthwhile. Thank you very much for your attention. It was a real pleasure being here today, and I'll be glad to answer any question you may have. Thank you.
Thank you very much. Thank you very much for your speech, and I go straightly to our second speech by Maria Quintes-Perez. Thank you very much.
Good morning, everyone. First of all, I would like to thank the organizers of this conference for all the effort they have put into making this event possible. I'm really glad to be here and to have the chance to contribute to today's discussion. Well, as you know, one of the main objectives of organized crime is to obtain economic gain. Therefore, a key strategy in combating this phenomenon has been to prevent criminals from enjoying the gains from their activities, with the aim of discouraging further offenses. However, it is often very difficult to prove that particular assets come from a particular crime. This is because criminals frequently make use of frontmen, tax haven, and complex corporate structures to obscure the connections between assets and their illicit origin. In response, various strategies have been developed to avoid the need for direct evidence in order to secure a conviction, focusing instead on targeting money that does not appear to match persons' lawful income. In this regard, Spain, like other countries, often relies on tax fraud and money laundering charges to sanction unexplained increases in wealth when there is insufficient evidence to prove the commission of a specific crime. Tax fraud is applied when someone has assets that do not match their legal income, but there is not possible to prove that they come from for a crime. As for money laundering, it was initially linked to the fight against drug trafficking, but has undergone significant expansion in recent years. And for example, in Spain, it's possible to use it from any predicated crime. In Spain, in addition to intentional money laundering, the law also punishes cases of serious negligence. This applies to those who, given the circumstances, could and should have been aware of the illicit origin of certain assets. For example, a bank employee who fails to properly verify the origin of a new client's assets. This is the kind of situation for which the law is understood to make sense. However, it also been applied to individuals who withdraw money from cash machines and send it by post, or simply move it from one bank account to another bank account. The courts held that the average citizen should have reasonably suspected that this type of jobs might have been connected to criminal conduct, as nobody pays for such an easy job. Spanish law also penalizes self-laundering. That is, when the perpetrator of the predicate offense launders the proceeds of their own crime. As the mere possession or use of assets is also penalized as laundering, this will mean penalizing, for example, a drug trafficker which use the money that he originates with drug trafficking for paying, for example, for the supermarket or for a taxi. However, the mere possession or use of assets derived from a crime is, in fact, part of the final stage of the offense. So if we sanction it twice for the offense, the predicate offense, and from money laundering, we will be infringing the principle of non bis in idem. So the courts in Spain have said that to sanction this possession as money laundering, the assets must be used or held with the aim, with the intention of hiding or distinguishing their illicit origin. The very broad range of conducts covered by money laundering legislation had led to some to argue that the offense is being used as a kind of catch-all provision to sanction virtually any behavior involving assets of criminal origin, confusing the political criminal function of this crime with the one of the confiscation. In any case, a conviction for money laundering requires to prove the criminal origin of the assets, and also that the person know or should have known this criminal origin. This last part is really difficult to prove. So usually what the courts often rely is on circumstantial evidence, like unusual increase in wealth, abnormal financial operations, connections with persons involved in criminal activities, or the possession of large amounts of cash. Another way to make a crime unprofitable is confiscation. As many colleagues speak about it yesterday, I'm only going to point out that in Spain, to apply the extended confiscation, our criminal code recommends paying special attention to certain indicators of the criminal origin of the assets. The very same indicators used to secure a conviction for money laundering. However, if extended confiscation is being applied, it's precisely because those indicators were not enough to convict it for money laundering. Otherwise, we will be applying the directo confiscation. Another problematic form of confiscation is that which allows the confiscation of assets held by third parties. The underlying rationality is that major criminals rarely keep property on their own names. They tend to register it under relatives, friends, or frontmen. If these third parties knows the criminal origin of the assets, they might also be committing the crime of receiving stolen goods or money laundering. And if they don't know it, they could be possible to use a civil figure which obliges them to return the assets to their legitimate owner. More recently, the Spanish legislator has introduced the offense of illicit enrichment, although it is restricted exclusively to certain public officials, namely authorities. This offense punishes authorities who, while in office or within 5 years after leaving, sees their wealth grow by more than 250,000 euros compared with their lawful income, and then refuse to explain where it came. With regards to this offense, it remains unclear whether the core of the wrongdoing lies in the failure to respond to the question of where the money comes from, or in the possession of assets that are disproportionate to one's lawful income and therefore suspected of coming from an act of corruption. In any case, what used to be a mere sign of a crime are now treated as a crime themselves. Something similar is proposed in the Article 13 of the draft directive of the European Parliament and the Council on combating corruption, which is currently under discussion. It wants to criminalize the intentional acquisition, possession, or use by a public official of assets which he knows that comes from the commission of a corruption offense, regardless of whether or not he took part in it. The alleged objective behind the introduction of this offense is to reach those cases in which it is not possible to prove that the person commits a crime of corruption. This typical configuration could be extended to other areas, for example, organized crime. This provision bears some resemblance to the offense of self-laundering and also to confiscation, but it appears not to require being carried out with any specific purpose. This raises some significant concerns in relation to the non bis in idem principle, if the act of corruption can be proved, and for that reason the person condemned by it, or the right to be presumed innocent if the initial crime of corruption can't be proved. In addition, it's not a major innovation because this conduct could already be punished for money laundering or use asset confiscation. In conclusion, there is a considerable range of measures in the law to pursuing the profits from a crime. Some of these overlap and all of them raise certain concerns. As my colleagues pointed out yesterday, the challenge before us is to remind the legislator of the importance of limits in criminal law, that not everything is permissible, even in areas as insignificant as those we are discussing today. Perhaps the issue lies more in the practical application of these measures than in the legislative gaps. Thank you for your attention.
Thank you very much, Maria. And we switch after these first two presentations that were more on the side, of course, of asset recovery, on confiscation and self-laundering. We go now to look at another perspective of the fight of organized crime and the possibility to use what the role could be of restorative justice in this area. So thank you very much, Alfredo Junior D'Alise. You have the floor.
Good morning. First of all, let me thank you to the organizer for this meeting possible, in particular to Emanuele Birritteri and Dr. Recchia and Yuto Yokohama. And thanks to my colleagues for their excellent contributions and very stimulating contribution. Today, I'm pleased to add together with them a restorative perspective to the brilliant themes we have heard so far. As Dr. Eka said, today I will talk about a few aspects of my ongoing research on restorative justice and organized crime. First, we'll focus on two very short definitions of restorative justice and organized crime, so that we can have the same references. Then I will explain why in an international forum like this, international symposium, I chose to focus only on the Italian provision. Specifically, I will explain the relevance of the Article 44 of Legislative Decree 150/2022 and why it offers a great opportunity. Lastly, I will finish with a concrete suggestion: develop mediator guidelines and frame restorative justice as a state response to communities harmed by organized crime. But let's start with the definitions. What is restorative justice? There are many definitions, but essentially it's a voluntary participatory process in which victims, offenders, and community representatives work together with a trained facilitator to acknowledge and repair harm. And we know that mafia type organized crime, in particular historical mafias in Italy, is a structured network based on secrecy, solidarity, and omertà, which uses violence, intimidation, and corrupt links to capture resources, influence politics, and control communities. In this scenario, Article 44 matters because it allows access to restorative pathways at any stage of proceedings, including the sentence. Sorry, I forgot. Yep. How to skip the slide. Okay. There are many definitions of restorative justice, you can see. Article 44 matters because it allows access at restorative justice pathways at any stage of proceedings, including the sentence enforcement phase. And that is important because during enforcement, the conviction is final, the fact-finding is complete, and many, not all, but many procedural risks that concern pre-trial or trial stages are absent. Given that, enforcement is a moment when resocialization measures are legitimately implemented and when sustained behavioral change can and should be supported in control settings. However, practice has diverged from the formal openness of the provision. Decree Law number 92 of 2024 amended the framework and excluded inmates subject to the special 41 bis detention regime, the so-called hard prison regime, from access to restorative justice programs. From my point of view, that exclusion reflects a penal populist tendency to treat restorative justice more like a custodial pair rather than as an instrument aimed to repair and reintegration. Despite that amendment, Article 44 still reaches the wider high security circuits. According to the national guarantor, these circuits includes 9,342 individuals, which is the 14.96% of the total prison population in Italy, about 1 in every 6.7 detainees. This group contains many of the most dangerous people in the penitentiary system, such as people convicted of mafia-type offenses. So let's clarify what we are talking about. We are dealing with people convicted of mafia offenses or crime connected to the mafia context. Individuals who are stable members of mafia organizations, sustain ties of solidarity and omertà, exploit associative bonds to impose economic and social control, use or threaten violence, conceal resources, and consolidate organizational influence. Until 2022, the legal order offered two practical paths. One provided normally based net benefit to inmates that decided to cooperate with the defenders. The other one sometimes guaranteed the same benefits even when collaboration was impossible or enforceable. Today, however, benefits are primarily available to cooperators, and that change raises a difficult question. What do we do with a mafioso who cannot or will not cooperate and is held under high security conditions? Formally, both cooperator and non-cooperators retain a right to a tailored treatment plan aimed at resocialization. The prison administration emphasized two central elements of such treatment when considering removal from the high security circuits. Basically, there are work and study. These two are essential, certainly, and explicitly taken into account. In addition to this, as you can see in the slide, the prison administration also considers other criteria. They are certainly objective, but more context-based rather than substantial, I think. Is this sufficient? I do not believe so. The mafia, we know, is complex, multifunctional, multidimensional, and if we treat it only as a criminal enterprise, kind of mafia SPA, we risk ignoring its cultural, social, and moral dimensions. If we rely only on repression, we risk leaving communities traumatized and alienated from the institutions, and also vulnerable to continued criminal influence. My proposal is to include the restorative outcome as an independent and additional criterion alongside work, studies, of course, financial checks, for the prison administration to consider when deciding whether to remove an inmate from the high security circuit. That's my point. Article 44's procedural openness gives us an opportunity. It allows the state to open the logical pathway, even with people our laws label as highly dangerous, provided we design appropriate safeguards. The central question becomes how to do this while fully respecting victims and their families, safeguarding investigative needs, and preserving legitimate repressive requirements. Those conditions are non-negotiable, I think, for a serious and responsible policy against organized crime. But they can be combined with the restorative approach, providing a very deeper meaning of justice. My proposal is concrete: develop clear, specialized guidelines for mediators who will work with mafia-related cases during the enforcement phase. Mediator in these settings needs specific training and protocols. They should operate under rules that clarify confidentiality limits, secure informed consent, set the sequence of interventions, and require close coordination with investigative authorities. Crucially, restorative process must include explicit safeguards to prevent interference with ongoing investigation and to protect victims' safety and dignity. Restorative justice in mafia context is not only an instrument aimed at individual offenders. It is also a public response from the state to communities harmed by organized crime, and especially communities in high-density mafia areas. Working together with local actors, the state can design reparative tools calibrated to local social realities. Such tools can restore a sense of proximity to institutions, empower communities to manage human conflicts, and strengthen civic resilience over time. Risks are real and varied. Yet I'm convinced that with a solid framework of rules and sound professional practice, the benefits can be substantial. Behind ordinary repression, civic resistance and community rebuilding can gain new force, and transformation, social transformation, moral, civic transformation becomes conceivable. Then I would like to finish with a sentence many of you know, but I think that still remains powerful. The mafia is by no means invincible. It is a human fact, and like all human facts, it has a beginning and it will have an end. And so, if the mafia is a human fact, let us confront it also with human instruments, and I think that restorative justice is one such instrument. Thank you for your attention.
Vi dovete invertire per le slide.
Ottimo, certo. Thank you very much for this presentation on yet another aspect of our dealing with organized crime. And we go now to the last one of the aspects of the facets we were looking at in our session. That would be the one of the protection of whistleblowers, witnesses and collaborators. So yet another perspective on this topic. So thank you very much. Maria Di Maggio, you have the floor.
Okay, perfect. Thank you. Good morning, and thank you for the opportunity to present in this event. My talk looks at three key figures that who help us expose serious wrongdoings inside and outside the organization, which are the collaborator of justice, witnesses of justice, and whistleblowers. And these three figures differ in legal status, in motivation, in process, and yet in high-risk context. My central claim is simple. We have a protection gap for whistleblowers in those settings, and we should close it with a calibrated legal solution. Can I? Okay. So these are the three figures, and we need to give a general definition about these three categories. So the collaborator of justice, collaborators of justice are offenders who cooperate with authorities and are typically members of or associates of criminal organization, as we know, and are motivated by leniency in sentencing. Their value lies in insider knowledge that can map structures, methods, and finances from within. So this is something that is also similar to whistleblowing because they have an internal perspective. So they are insiders too. Witnesses of justice, it's different because they are uninvolved civilians who testify out of civic duty. So they are outsiders and they don't participate normally in the crime dynamics. Whistleblowers are non-offending insiders who report in the public interest, and typically because they learned of a wrongdoing through their work or professional duties. They are neither offenders nor accidental bystanders. They sit inside the organization, of course, as I said, and so they can be public administrators and people that work in the organization and can detect early signals. So they also can report about just easy malpractices and wrongdoings, not only about crimes. So these three figures, distinct pathways, are distinct pathways to truth. We have an offender insider, a civic outsider, and a non-offending insider. And these differences matter because they determine which protection law are available and also how quickly we can protect someone. So these are like some key differences, like just a scheme that a difference between these three figures and the legal status, the main motive, and the typical forum, and then of course the typical protection, which is strong in the first two cases and a little bit limited in the case of whistleblowing. So we have a robust identity change, robust kind of protection with identity change, relocation, financial support for collaborator and justice witnesses, and a fragmented, workplace-centered and based on anti-retaliation protection for whistleblowing. And there's a risk of mismatch, because what happens if a whistleblower then deals with crimes that are connected to organized crime in a certain organization and certain body. So there's a problem, especially with mafia and eco-mafia disclosures, because then we have a criminal exposure, and the protection is mainly administrative for and compliance from point of view for the whistleblowers. And that's why do we talk about environmental, the eco-mafia and organized crime related to whistleblowing? Because Recent reform have moved the needle, and the directive 2019 of number 1937, and in Italy was implemented with this legislative decree 24/2023, made some progresses in whistleblowing, but yet whistleblowing is still just employment linked. Then with the directive of European Union 2024 number 1203, we have an express reference to whistleblowing and the whistleblowing directive. So that organizations should implement whistleblowing and whistleblowing protection in the environmental field. What happens is a lot of time environmental crimes are linked to also organized crimes. So what happens when someone is reporting an environmental crime, and this is also linked to organized crime? So there's a gap, and we don't have a disclosure outside the work context that is protected also by the whistleblowing directive, and also all the implementation laws like this of all the member states. And there's a limited space for anonymity. So what happens is that the first reporters are often not employees. So we have, with environmental crimes and possible eco-mafias, citizens, activists, independent professionals that make some disclosure or anyways reports about what? Illicit waste, land use, public procurement, and so there must be a policy ask to recognize anonymous and extra work reporting where risk is high. And so this is the proposal in my paper, and also in this speech, my talk. And high risk whistleblower in these cases. The trigger is that disclosures on mafia type, or is this kind of disclosure on mafia type or systemic environmental crimes that are different, and that we must recognize some kind of safeguards, such as identity shielding, relocation, financial assistance, and rapid risk assessment. And also about the access, we must recognize a broader access. So also independence of employment, allow qualified anonymity, and the liaison with the protection programs that are different. And so this is the conclusion of my presentation. We have two takeaways from this. We have converging risks with these three figures, but diverging protections. So we must also interrogate ourselves how we converge these three figures when it happens that they overlap a little bit. So close the gap within the higher risk whistleblowing status. And so move from a compliance to a democratic engagement, and enable anonymous and extra work reporting where public danger is substantial and we have a higher risk context. So really, thank you, and for
Thank you very much. Thank you very much, all four of you, not only for the wonderful speeches, but for not letting me have to do the most difficult job of the chair, of course, of limiting your speeches, because you were all perfect in your time. But I think that we have now 10, 15 minutes maybe for our discussion. So I will open the floor for your questions, your intervention for our speakers. Do I need to break the ice? Bye.
May I? Okay. A question for Alfredo. Very interesting. Okay. Very interesting. So I believe your proposal, no, in considering also the restorative outcome to put detainees outside the high security system.
Yeah.
But how to deal with the problem of avoiding contact with the organization and the external world? So if the restorative outcome is not linked with the evidence of the fact that there is danger of new contacts with the original organization. I don't know if the question is clear.
Yeah, it's clear. I agree with you. In fact, I say that my proposal is to include restorative outcome as an additional, but independent criteria. Additional. So in the slide, there are many of. I put many of criterion for the classification from the high security circuits, but this criterion is not. It's not alone. It's a complex system of valuation. But now there are only economic-based criterion. So I could be. It's more interesting if there are other criteria that I think there are more substantial. So restorative outcome, the restorative outcome there is when you have a completed a program. So 1 here, 2 here, 3 here, I don't know, but it's a serious criteria, I think.
Thank you very much. Professor Burgo.
Only a quick question related to the presentation concerning whistleblowing and the other figures. I was interested in your conclusion, because if we look at whistleblowing, so traditionally the idea is, as you said, an insider, but within a licit organization, and the perspective in which the idea is to protect, because theoretically, whistleblowing should remain within the organization, and also it should be protected by the top, because the idea is that you are, I would say, it is not exactly so with the new directive, but a sort of pillar of the compliance in a broad sense. So if you would like to converge, as you said, the different figures, can you deal with this problem? And the idea is to make closer whistleblowing to the witness of justice, or with which figure?
Thank you very much for your question. Yeah, the problem came to me because I was studying sustainability in criminal law. So I started also to read and study this directive about environmental crime and environmental criminal law. And then I noticed that there was the reference to the whistleblowing directive. So I was asking myself, how should we align this, like whistleblowing protection, to this high risk context? And I think with the kind of directive that we have about whistleblowing, this is just not possible. We should create this other whistleblowing, high risk whistleblowing, which is more similar to the so-called bell ringing. So also the outsiders of the organization, they can report something, and it would be like a sort of hybrid kind of report between the witness of justice and the bell ringing, this kind of whistleblowing that is more like open outside the organization. I called that. I didn't want to give also another definition about bell ringing, but I will do that in my paper. So, thank you.
Are there any other questions? I have one actually for Maria, so I will just take the chance. You were talking in your speech about how important it is to have limits, that not everything is possible in criminal law, even in a significant area of crime, such as organized crime. So I wanted to ask how significant it is in Spain. You've talked about the illicit origins crime that was introduced. So I was curious about who are addressed by these new crime. Which are the subjects that can commit this crime, that should report on their finances? So how broad it is? It only member of the government, of the national government, the national parliament, judges, or is even, I don't know, a teacher at the elementary school, at the secondary level? How broad is the spectrum of the addressee of this crime? Thanks.
Thank you for the question. Well, it's not clear exactly which are the subjects. What we know is that it's not any kind of public worker, because it's limited to authorities, which is defined in the criminal code. They say what are authorities. And for example, authorities are the member of the Congress, some important figures at high level, the president of regional Congress, also the regional parliament. But the problem, what I say that is not clear exactly who can be targeted, is because our legislator says that this crime is introduced following the one in Portugal. And the one in Portugal comes from an administrative legislator, which is the one who says, okay, all the public servants have to tell me where the money comes from. So they have to declare, and if they don't declare, they will be sanctioned. And if we notice that they try to hide the origin of the asset, we will punish it not in an administrative way, but in a criminal way. But the thing is that in Spain, we don't have only one legislation about who has to declare the information, or how to do when somebody doesn't declare it properly. We have different kind of legislations. For example, the judges, which are authorities, also the prosecutors, they don't have a proper legislation. They now have an agreement that because they decided only the most important judges to make public their gains, but this is not legislated. And for example, we have some regional. We have a legislator to the main directives of the state cargs, but not of others. And this legislation has a figure to check and to make sanctions. But for example, the legislator made for the members of the Congress, they aren't provision of sanctions if they don't declare the money. So we have so many different legislators, and we can't tell who commits the crime, because if it is not an official or a person, an institution selected, appointed by the law to check the economics of these public authorities, who can do these requirements, that because the configuration of this crime will be different, no? I study different countries, and they do it differently. And what they do in Spain and also in Argentina is to say, okay, it's not only that you have an increase in your wealth, that also somebody asks you to explain where it comes from, and you can't explain it. But who can ask you? We don't know in Spain who can ask you, because not all the laws who regulate this obligation to declare your money prevent a figure who can ask you. So who can ask you? The police, the judge, but if who asks you is the judge, this not goes against the presumption of innocence on the right to remain silent, because you are completing the crime just when you are being asked for the judge. When you, I mean, for me, it's a really crazy crime. I hope it's not being used. But my tutor of thesis told me that he saw a sentence. I suppose it's in a small degree they can presentate a recourse, but in that sentence it's being used.
Thank you very much. Are there any other questions? Otherwise, I would thank everyone again of the speakers of this panel for the wonderful presentations. And thank you very much for you all again. And now the floor to
Then we will move fast to the last panel, I think, of the second session of the Congress. Okay, thank you very much. This panel will be introduced by Marco Colacurci, Assistant Professor of Criminal Law at the University of Campania Luigi Vanvitelli, and will be chaired by Giuseppe Di Vetta, Tenure Track Assistant Professor of Criminal Law at Sant'Anna School of Advanced Study of Pisa. Maria, you have slides? Okay, can you send me? Are ready to? Okay, let us arrange everything. So Marco, the floor is yours for the introduction of the panel. Thank you.
Thank you, Emanuele. And please let me thank the Young Penalist Committee for the organization of this event. I think it has been a great 2 days of exchange, of friendship, of gathering together. I think it's the academic environment at its best. So I would like to thank Emanuele, obviously, the other young panelists, Professor Gullo, Professor Mongillo, but I think it's a real enriching experience, not only for young panelists, but for a little bit older panelists, because I just passed the threshold for being young panelists, but also for more experienced ones. So it is really great to be here today, and I'm honored to do the introduction to this panel. I will not steal minutes from the presentation of the panelists, but the topic of organized crime, transnational dimension, and illicit businesses, it's a topic that deserves peculiar attention, because we're dealing obviously in this day with organized crime, and we know that from a criminological standpoint, there is a strict and growing relationship between organized crime and illicit business activity, the infiltration, the ramification of organized crime into apparently legitimate activities is growing, and we assist from a criminal standpoint to an hybridization of model, because when we think about organized crime, we have harsh reaction from an administrative, from a criminal point of view, with tools that are conceived for having a harsh reaction to organized crime. On the other end, when dealing with illicit business activity, we have also a different paradigm, that this is the one of corporate crime liability, which is grounded on different premises and on public-private partnership. So those are two different paradigms that can interact differently in tackling this phenomenon. So I think it's a very stimulating field of research and of reflection. We have seen during this day how the tools conceived in fighting organized crime, confiscation, but also the Italian legislation against corporate crime are used also in the fight of organized crime and vice versa. So also in the introduction of Nicola Recchia, it calls for asking what is organized crime, and I think this should reflect also the kind of tools we use and the paradigm we use. And I think in the presentation we are going to listen to, this topic will be addressed also clearly with regard to the transnational dimension of those kind of crime. And obviously when dealing with organized crime, the international legislative framework probably better led to address those kind of crime. But those are just some short reflection. I will not steal more time and will give the floor to Giuseppe and to the panelists. Thank you.
Thank you very much. Thank you very much, Marco, for brilliantly introducing the panel. I'm Giuseppe Di Vetta. Good morning, everyone. But who I am is not so important. So I would like to thank the organizer, AIDP, and friends, Emanuele Birritteri, UnitelmaSapienza, who welcomed us, etc., for inviting me as serve as chair for this insightful panel. I'm going to gradually introduce all the panelists that made up this panel, and I was ordered by Emanuele Birritteri to be short and to ensure that the timing is observed. So it's a very bad job that someone will undertake. So I'm going to open the panel, and the first panelist will be Maria Castro Corredora. Is the pronunciation okay? Okay, so perfect. She's assistant professor of criminal law at the University of Santiago de Compostela. She's going to discuss an extremely insightful issue concerning the exclusion of enterprises from the public sphere and from public procurement context when these enterprises have been considered under the law to be involved in illicit or unlawful conduct or influenced by organized crime. So the floor, you have the floor. Thank you very much, Maria.
First of all, I would like to thank the organization for the opportunity to share this presentation with all of you. The criminal markets associated with organized crime are many and varied. And okay. Yes. Thank you. Therefore, they require decisive actions to reduce their impact. In addition, there is growing concern about various criminal manifestations of organized crime, which also generate great social alarm, making it necessary to monitor them as serious crime. This is the case, among others, of various forms of institutional corruption and socio-economic crime linked to public procurement. Exclusions from public procurement procedures are part of a dynamic and flexible set of procurement rules common to all member states of the European Union to obtain high-quality goods and services in return for the delivery of public funds. As a tool of social, environmental, and innovation policy, they are integrated among the resources available in the legal system to prevent corruption and other forms of pressure and influence linked to organized crime, aimed at consolidating positions of political power, for example, as pressure groups or lobbies, with the objective of influencing institutional decisions. In the context of European Union and its commitment to transparency, they are a useful tool for the effective control of risk sectors that have close contacts with public institutions. These measures have achieved significant relevance in the European context, so now they represent a real threat of exclusion from the possibility of concluding contracts or concessions with the public sector. Although the initial legal framework is very heterogeneous, the institutions of the European Union have undertaken an important task of further approximating the different national legislations. This process has been through a set of directives known as the fourth generation directives. Their content is very similar, and they design two different models of exclusions, a mandatory model and a discretionary model. The mandatory exclusions requires economic operators to be excluded from public procurement for various reasons, arising from judicial and/or administrative decisions. In the field of criminal law, we are interested in the first of these causes, which establishes that contracting authorities shall exclude an economic agent from participation in a procurement procedure when they find out that the economic operator has been convicted by final judgment for committing certain offenses, such as participation in a criminal organization or corruption. In addition, the European regulation mentions other kinds of offenses, such as fraud, terrorist offenses, money laundering, or trafficking in human beings. The decision to exclude a candidate lies with administrative authorities and, in particular, the contracting ones. This aspect is somewhat controversial. If the ground of the exclusion comes out of a final criminal conviction, it's highly questionable whether the administrative authorities are competent to decide on this matter. The transposition of this set of rules into legal systems has been carried out in various ways. In the following minutes, I will focus on the Spanish case. Spain has opted to apply a hybrid or combined system. We have two different systems, one in administrative law and another one in criminal law. In the field of administrative law, another question arises. Are we really dealing with manifestations of punitive administrative law? If we answer yes to this question, this could be highly relevant when the prohibitions are the result of a criminal conviction. We must consider the effects that this might have with certain guiding principles of criminal law, such as ne bis in idem, culpability, and non-retroactivity. If we answer no to this question, we will have to ask ourselves whether it's possible to consider them onerous legal consequences without a punitive nature or status. Attempting to answer this question is also important in order to guide which are the aims of these measures. In the field of criminal law, the legal nature of the exclusions is unclear and confusing. Are we talking about principal penalties, accessory penalties? It depends on the nature of the offense. That's not clear. We have designed three different types of exclusions with different content. Deprivation of the right to enjoy tax or social security benefits or incentives, the deprivation of the possibility of obtaining subsidies or public aid, and the main prohibition on contracting with the public sector. Regarding to the liability of natural persons, these measures are not regulated separately in the general part of the criminal code as they should. Therefore, they are considered to be included in the special disqualification from exercising certain activities. Furthermore, the guarantees of the principle of legality, especially nulla pena sine lege, require the exclusion to be restricted to the rights and activities whose prohibition is expressly provided for in the criminal code, which also introduces different distortions in this area as a consequence of the terms in which certain offenses are drawn up. Regarding to the liability of legal persons, these penalties are regulated separately in the general part of the Criminal Code. They are considered serious penalties and have a special preventive focus aimed at preventing continuation of criminal activity. The modalities are the same for natural persons and with the same content. So, to conclude, there are many questions surrounding these prohibitions. Their nature and scope of application is not clear. They can be very deterrent, especially the prohibition on contracting with public sector, and they can be very burdensome for entities whose activity is carried out in professional sectors with a large public presence. The main problem is that they are not enforced, so maybe we could think why they are not enforced. The increased prominence has led to their inclusion in recent regulations, such as the Environmental Directive or the proposal of Directive Anti-Corruption. So I would like to share with you a final thought. Can we therefore talk about new horizons for the application of these exclusions? I don't have an answer to this question yet. Thank you very much for your attention.
Oh, okay. The second panelist is Aneta Fraser.
Yes, hello,
Can we
good
hear
morning.
Aneta?
Can you hear me?
Hi.
Hi.
Good morning. Aneta
Hi.
is going to present a paper addressing a very important point consisting in the normative and practical intersection between transnational criminal law concerning organized crime, for instance, the UN Convention Against Transnational Organized Crime and the UN Framework Against Transnational Organized Crime and international criminal law. So, please, Aneta, you have the floor.
Thank you. Thank you so much, Professor, for introducing me. And thank you so much for organizing the event. I regret that I am not here in Rome, but maybe there will be another opportunity. So thank you so much. And yeah, so today I would like to talk about the relationship between the Palermo Convention and the Rome Statute, two different legal acts. And just to address a possible question right away, I'm not suggesting that organized crime has become part of international criminal law, but I would like to show today that we can look at it through that lens, that there are situations where participation in organized crime starts to resemble or even overlap with international criminal law. Okay, now changing slide. So today I will be moving between two different legal frameworks, as Professor aptly stated. On the one hand, we have transnational criminal law. On the other hand, we have international criminal law in the strict sense. So the key question for today is how close do these two regimes actually get? And more specifically, can participation in organized crime ever reach the level of international criminal responsibility? Before we move further into the legal discussion, I want to pass for a moment look at the statistics also provided by Global Initiative Against Transnational Organized Crime. The Global Initiative has shown that in many countries, organized crime is no longer something beyond the state. Instead, it increasingly operates from within through state-embedded criminality. So this means that parts of national officials, government could become involved in or dependent on criminal networks. And that also creates a very clear problem. So if those who are meant to enforce transnational instruments are also involved in organized crime, how can those treaties work as intended? So I'm speaking very generally, but finally, to put this into perspective, here on the slide, you can see the map from the Global Initiative's website. You probably maybe know this project, but if you don't know, I have included the link on the slide. It is a very valuable resource that provides some concrete data. So the index is made up of several different indicators that measure various aspects of organized crime and its resilience. For this slide, I focused on just one of them, the indicator of state embedded actors. It refers to criminal actors who are embedded in act from within the state's own structures. So as always, the scores range from 1 to 10, where higher, of course, numbers reflect more severe problems. And according to the index from 2023, the global average of state-embedded criminality has now risen to almost 6 out of 10. Of course, these figures are from 2023, but as far as I've seen, the next edition of the index for 2025 is expected to be released soon. For that reason, we also need to look at other maybe possible frameworks. It turns out that maybe in some respect the Rome Statute may not be as far removed from the Palermo Convention as it first appears. I decided to use crimes against humanity as a point of reference under the Rome Statute. I will explain why I have excluded genocide and war crimes a bit later. So to establish individual criminal responsibility for a crime against humanity, certain elements must be proven. I don't have time to explain all of them, but at the outset, you can see that attack must be widespread, systematic, large-scale, organized, involving a substantial number of victims. So this high threshold already excludes most ordinary forms of transnational organized crime. And of course, the attack must be carried out pursuant to or in furtherance of a state or organizational policy. Sometimes it is assumed that a policy of tolerance is sufficient, so when authorities consistently ignore, for example, trafficking networks. And this expression of common purpose comes from Article 25, paragraph 3, letter D of the Rome Statute. The provision I am discussing is a form of participation, covers cases where a person makes a significant contribution and just has the knowledge of the group's intention to commit the crime. So the mere knowledge of the group's intention is totally enough under this provision. And I think that is quite realistic if that person X is, for example, a state-embedded actor, does not execute the crime, but, for example, gives money or funds the criminal activity and has the knowledge of group's intentions. Here on the slide, we can see the definition of trafficking in persons. It has 3 elements: acts, the means, and the purpose. Of course, with this exploitation, I think we are all familiar with that provision, so I can skip that slide. And coming back to the Rome Statute, of course, it is not as simple as saying that we can just apply the Rome Statute whenever we want. And that's what I wanted also to underline here, that there are a number of procedural jurisdictional requirements that have to be met. Again, I will not discuss all of them. Usually, for example, the ICC can operate if the alleged crime was committed on the territory of a state party or by a national of a state party. So in practice, this can also create quite a few implications. For example, if we take the case of human trafficking, victims may be recruited, for example, in one country that is a state party, but exploited in another that isn't. So sometimes it is also assumed that in such situations, the ICC could only exercise jurisdiction over the part of the conduct that took place within the state's territory before the victims cross the border. And finally, the principle of complementarity. In simple terms, ICC only acts when national courts are unwilling or unable to do so. And another problem arises when it comes to subject matter jurisdiction. So the crimes themselves are also defined in very specific terms. When it comes to genocide, some elements of human trafficking, such as forced transfer, cruel treatment, exploitation, transfer of children could overlap with acts considered as genocide. However, the real issue here lies in the mental element. Genocide requires a very specific intent, the intent to destroy a particular national, ethnic, racial, religious group that does not fit most examples of organized criminal activity, which are usually motivated by profit. So war crimes, on the other hand, require an armed conflict and a clear link between the act and a conflict. But organized crime often take place in peacetime, as I mentioned before, even with ordinary governance structures. And that's why, in my opinion, crimes against humanity are the best fit, and certain forms of trafficking enslavement, slavery, and forced prostitution could be considered as crimes against humanity. So speaking of the provision I picked from the Rome Statute, that also is, in my opinion, the best fit when it comes to conduct that contributes to organized crime. The provision stipulates double objective element, an individual contribution, of course, and a group crime, and also some subjective elements like the common purpose of the group, or either the purpose of furthering the group's criminal activity or just knowledge of its intention to commit a crime. So providing funds to a group acting with a common purpose could imply the criminal liability under this provision. Of course, there are other provisions in the Rome Statute. When it comes to the attribution of criminal liability, there is also one that relates to assisting, aiding, abetting, and in many ways that could also apply to the kind of conduct I am discussing. However, the key difference here lies in the subjective side. According to the provision I picked for the purpose of today's discussion, the mere knowledge, just the knowledge of the group's intention is enough to be held liable. So to wrap this up, here is a very simplified summary of what I have discussed. So for instance, we have person X, a citizen of state A, who funds or supports the activities of an organized criminal groups in territory of state B. I mark the state B because it can and often will be the case that human trafficking takes place between different countries. For simplicity, I listed one, state B, as at this stage we already have the transnational element, given that person X provides funding from the state A. So in the first scenario, if person X acts as a state embedded actor, there is, of course, no guarantee that they would be held liable under national provisions. And this lack of accountability, of course, may stem not only from weak domestic enforcement, but also from, political considerations or from institutional barriers such as immunities. And by contrast, in the second scenario, under the Rome Statute, if necessary conditions are met, there could be a legal basis for holding person X before the ICC, especially that official roles do not exempt anyone from criminal responsibility before the ICC. And on the slide, you can see a very bold postulate. I don't have answers for that question yet. It is just to provoke a discussion. Actually, this is something I kept hearing whenever I mentioned ICC to anyone who specializes more in transnational criminal law, that what maybe the world needs is a transnational criminal court, one capable of addressing cross-border conduct. Of course, that is still a rather ambitious and far-reaching idea, perhaps more of a postulate rather than something we can expect anytime soon, but it's, I think, worth to mention. And thank you so much for your attention. I will be happy to take any questions now or maybe by email. And yeah, thank you so much.
Thank you very much, Aneta, for your brilliant presentation. I really appreciate it. So it's the time of Federica Zazzaro. Federica Zazzaro is a PhD candidate in criminal law at the University of Campania, Luigi Vanvitelli. She's going to present a paper addressing the intricate relationship between organized crime and corporate criminal liability under Decreto Legislativo 231, Legislative Decree number 231, 2001. Thank you, Federica. The floor is yours.
Good morning to everyone. First of all, I would like to thank Marco Colacurci and Giuseppe Di Vetta for introducing me. And of course, I would like to thank Emanuele Birritteri and all the organizers for giving me this opportunity. Today, my presentation is focused on the relationship between organized crime offenses and corporate criminal liability following the inclusion of the associative offenses among predicate crimes set forth by Legislative Decree 231 of 2001. Okay, so as known, the introduction of organized crime offenses through Article 24 ter marked the decisive shift in the regime of corporate criminal liability. Pursuant to Article 24 ter, an entity may be held liable for a range of criminal offenses, including the criminal association crimes, the crimes committed by employing the typical methods of mafia-type organization, or with the specific intent of facilitating the activities of a criminal or mafia association, the crime of political mafia electoral exchange, and the offense of kidnapping for the purpose of extortion. So the inclusion of the associative offenses in the closed list has created significant theoretical and practical challenges. Given the heterogeneity of predicate crimes under Article 24 ter, the central question has arisen as to whether its interpretation should follow a restrictive or an extensive approach. Of particular concern is the risk that the entities could be held liable by means of associative offenses for crimes committed within the associative organization that are not expressly enumerated in the degree. So today I will engage critically with three main topics. The first issue is that the inclusion of associative offenses could violate principle affirmed by Article 2 of the degree, especially the legality principle. The second issue concerns the compatibility between the criteria for attributing liability to legal entities with the characteristic of associative offenses. And the third issue is about the incorporation of associative offenses that raises a complex implication for the adoption and implementation of corporate compliance programs. So starting from the first topic, the introduction of Article 24 ter has raised a significant issue regarding the compatibility between the associative offenses, which may potentially broaden corporate liability to an indeterminate range of crimes, and the legality principle, which stipulates that the liability of legal entities is strictly limited to a closed list of offenses expressly enumerated in the degree. So a central question has arisen. Can an entity be held liable for a predicate offense not explicitly provided for in the degree? And in that specific case, can an entity be held liable only for the offense of associative offenses or also for the underlying crimes not included in the degree? In particular, this issue has become most relevant with regard to the application of anti-mafia prevention measures to entities for their involvement in association offenses. So in some cases, the Supreme Court has admitted preventive seizures aimed at confiscating profits, identifying an autonomous patrimonial advantage arising directly from the underlying offenses, even if they were not listed as predicate offenses. However, in other cases, the Supreme Court has adopted a more guaranteeing interpretation, according to which profits derived from crimes not included in the legislative degree cannot be confiscated, even if they are instrumental to the criminal association offenses. So moving on to the second issue. The second issue concerns the compatibility between the identification of the criteria for attributing liability and the characteristics of associative offenses. Pursuant to Article 5 of Legislative Decree 231 of 2001, corporate liability requires that the offense must be committed in the interest or to the advantage of the entity by a person in position of authority or by a subordinate where the offense results from the lack of supervision or control. However, establishing whether an associative offense can independently satisfy the interest or the advantage requirement presents significant difficulties. So this raises an important question. Is the mere existence of a criminal association within or through the entity sufficient to demonstrate an interest, or is there a need to demonstrate that the organizational structure has provided specific benefits? There is a risk that an entity could be held liable for any interest or advantage arising from the underlying crimes committed within a criminal organization, even if those are not explicitly provided for in the decree. Recently, the debate on that issue has been shaped by an important ruling of the Supreme Court of 2024, as stated by the court, in order to establish the liability of a company with reference to Article 24 ter, the relevant offense must be the crime of a criminal association under Article 416 of the Criminal Code. If instead the interest or the advantage were evaluated with reference to the subsequent crimes pursued by the association, this would breach the fundamental legality principle. So this decision highlights a clear trend towards a more restrictive and rights-oriented approach that provides stronger safeguards for the entity. However, despite this recent decision of the Supreme Court, questions have arisen regarding the correct interpretation of the interest or the advantage. In fact, in the context of organized crime, the two alternative criteria could potentially be absorbed into a generalized notion, into a broader notion of corporate infiltration or contamination. So in certain rulings, the court identified an interest or an advantage in the structural or operational benefits that the association provides to the entity, including facilitating illicit contracts or monopolizing markets. For instance, in the Supreme Court decision of 2022, the court held that the use of the mafia intimidation to consolidate the market position of the company demonstrated a clear organizational benefit, even in the absence of a direct profit from specific illicit operation. So moving on to the third and the final issue, the inclusion of associative offenses among predicate crimes raises a significant concern regarding the compatibility and the effectiveness of corporate compliance programs, especially in light of their preventive function. So this issue becomes critical with the extensive interpretation of Article 24 ter, according to which corporate liability may arise not only from the association itself, but also from its predicates crime. So the Supreme Court, in a ruling of 2023, stated that the entity must evaluate which risks related to offenses it should minimize, including those related to the offenses not listed as predicate offenses. However, adopting this extensive interpretation would undermine the compliance system set out in the decree, as an organizational model could reasonably be expected to prevent the limitless range of crimes that a criminal group might commit. Concluding, this presentation highlights the problematic aspects arising from the incorporation of Article 24 ter into the legislative decree. Despite the adoption of a rights-oriented approach, some questions still remain unresolved. On one hand, the court's broad interpretation of the interest of the criteria for attributing liability has led to a broader notion of the interest or the advantage, which could be incompatible with the principle of personal liability. On the other hand, the extensive reading of Article 24 ter could undermine the effectiveness of corporate compliance programs in their preventive function. To conclude, the Italian framework faces a structural tension. While extending liability to the criminal purposes of associations risks neutralizing the compliance defense, however, limiting liability to the association itself makes it difficult to identify practical and effective measures within corporate structures. Thank you for your attention.
Thank you very much, Federica. So Last but not least, the floor goes to Candida Maria Elide Misorigo. Candida is a PhD candidate in criminal law at Milan University, Cesare Beccaria Law Department. Her paper will critically discuss the progressive decline of traditional criminal law tools in addressing mafia-type infiltration into the so-called formal economy. Criminal law has been replaced by other hybrid or not criminal or not so criminal measures. How should we evaluate this decline? Candida is going to answer. Thank you very much.
Thank you very much. Good morning, everyone. I would like to express my sincere gratitude to Professor Scolacurci and Giuseppe Di Vetta for the introduction. Okay. My speech today will focus on the evolving relationship between organized crime and corruption in Italy, as it will be discussed more extensively in my written work. It focuses on the infiltration of mafia organizations into public procurement. Public procurement is one of the main challenges for integrity of Italy's economy and public administration. Mafia groups are strongly attracted to this sector, which makes up around 12% of the national GDP and brings in over 40 billion euros each year to criminal networks. Their interest goes beyond limit. Public contracts allow them to control territory, gain social consensus for employment, build networks with entrepreneurs and officials, and distort market competition. Managing public funds also accelerates the financialization of mafia activities. This dynamic clearly emerges from two major court cases, Emilia and Cavalli di Razza trials, both confirmed by the Supreme Court. They revealed how mafia organizations have deeply infiltrated the legal economy and adapted to the new environment. In Emilia trial, the 'Ndrangheta built a structured presence in Emilia-Romagna through intimidation, corruption, false invoicing, and control of public contracts, aiming to eliminate competitors and reinvest illicit profits locally. Cavalli di Razza showed similar patterns in Lombardy, involving extortion, fictitious companies, and criminal structures integrated into the regional economy. These cases illustrate that today's mafias rarely rely on violence. Their methods are smart and hard to uncover, as they're using compliant advisors, legitimate-looking companies, subcontracting chains, bid-rigging cartels, and tax fraud schemes. To counter this infiltration, Italy has developed a complex system combining both prevention and repression. On the preventive side, we have discussed in the previous panels, especially yesterday, the main preventive instruments. So they're the so-called preventive measures and the anti-mafia bans, interdittiva antimafia. I'll just add that companies wishing to take part in public tenders must provide for contracts above a certain amount of money and in certain sectors anti-mafia documentation proving they have no links with criminal groups. On the repressive side, on the other hand, in addition to the traditional crimes against public administration, criminal law includes specific offenses relating to public procurement. In particular, Article 353 punishes interference in tenders through threats, collusion, fraud. Article 353 bis targets manipulation during preparatory stages to favor certain companies. Lastly, Article 512 bis, as amended in 2024, punishes fraudulent transfers of assets or fake ownership to evade anti-mafia checks in contracts. Despite its sophistication, the system faces major challenges. Firstly, subcontracts below 150,000 euros are exempt from mandatory anti-mafia checks, a loophole that can be exploited by splitting contracts or creating chains of subcontracts. The system also tends to react after the emergence of indicator crimes, meaning the investigation begins when the infiltration has already been found by the prosecutors. This shows a heavy reliance on criminal investigations rather than administrative investigations. Indeed, there are organizational limits. Many local police offices responsible for verifying anti-mafia documentation are understaffed, so checks often relies on database rather than in-depth investigations. Information sharing between police and prosecutor has improved, but challenges remain. Finally, there are legal tensions between anti-mafia bans and preventive measures that has already been discussed in the previous panels. This brings us to a crucial point. The expansion of mafia bans and preventive measures, tools that have critical issues, have been accompanied by a decline in criminal responses, on which the system partly depends. The most relevant provisions in this sector are those concerning crimes against the public administration. Corruption cases, for example, are notoriously difficult to prove. There is often no clear victim, and the agreements are confidential. The 2019 Spazzacorrotti law, under supranational impulse, extended to corruption officers certain investigative tools used in mafia cases, such as undercover agents and domestic wiretaps. However, these tools are not used in practice. Evidence remains elusive, and the prosecutors usually resort to lesser charges where such tools cannot be applied. The situation has worsened with the abolition of the offense of abuse of office, which often helped uncover mafia interference, especially in small local administrations. Its removal leaves important gaps in the law. Another issue concerns bid rigging, so Articles 353 and 353 bis of the Criminal Code. These offenses are now out of step with current procurement rules. Indeed, while administrative law has been repeatedly updated, most recently in 2023 by introducing more flexible and negotiated procedures, criminal law has not followed. This gap is evident in case law. First, once applied these crimes broadly, but now following the Constitutional Court's warning to respect the principle of legality, the Supreme Courts limit them to fully competitive tenders, excluding direct awards, negotiated procedures, or public recruitment competition. The consequence is that many of the procedures mostly used today, those that are more flexible and adaptable, fall outside criminal protection. This creates a double problem. It weakens the fight against corruption and organized crime in public procurement, and it also generates uncertainty for honest operators, discouraged by unsteady judicial interpretation. Lastly, the 2024 reform of the offense of fraudulent transfer of values, Article 512 bis, targeting fake ownership used to evade anti-mafia checks, marks a positive step. However, it helps punish down schemes, but it doesn't help to reveal new criminal dynamics. So, to sum up, nowadays, an updated legal framework risks opening new gray areas that organized crime can exploit. A coherent reform of criminal law on public procurement is therefore necessary. The legislators need to update the terminology and structure to reflect today's realities. This reform, however, must respect the principle of legality and acknowledge the complexity of adapting criminal law to a field, such as the one of public procurement, that is constantly evolving. Moreover, relating to public procurement, two key weaknesses is that first, direct awards cannot be prosecuted under bid rigging rules. And second, subcontracts under 150,000 euros are exempt from mandatory anti-mafia documentation checks. These two gaps open gray zones in control systems, which organized crime can exploit. It is also crucial to strengthen local investigative structures, increasing staff and specialized training so that preventive checks can lead to criminal investigation and not the contrary. Moreover, prosecutors should avoid what is known as label fraud, so the use of vague or generic charges to fill the gaps left by the abolition of offenses such as abuse of office. It is essential that indictments are clearly formulated. However, this is only possible if the criminal justice system has the proper tools to tackle mafia infiltrations. To conclude, the criminal justice system must once again play a central role as the main instrument of repression. Although in general, the reduced use of criminal law can be seen as a positive sign, especially nowadays, because it shows a commitment to due process guarantees. When facing a serious phenomenon like organized crime, this limitation cannot be replaced by instruments that do not offer the same guarantees. Thank you very much.
Thank you very much, Candida. Thank you very much for your brilliant presentation. I believe I met about timing and self-timing as well. Thank you. So the floor is open to question, reflection, observation, objection. Thank you, please.
Thank you very much for the insightful presentation. I have a question for Aneta, because I think the perspective that you are studying is really interesting, from organized crime to the ICC, especially right now related to the non-state actors that are the discussion on non-state actors and terrorist movement. And so I wanted to ask you, do you have a practical example? Because I'm trying to understand, I don't know if it can be Boko Haram or I don't know, the Libyan army that is not recognized as an army anymore. So the case Al-Masri can be related to an organized crime in the ICC cases. But I'm thinking myself, if there is a practical example on the nowadays word. Thank you very much.
Thank you. Thank you for your question. To be honest, I guess I studied mostly cases where there was responsibility, criminal liability under the provisions that consider participation in crime or direct perpetration. Because before the ICC, we have individual criminal responsibility. So mostly there are some cases where a national leader of the group or the group of the leader of the group is held responsible. However, I cannot now give you a practical maybe example of the group that was held responsible under the ICC, because I mostly studied individual cases. That's why I also made my presentation about, I focus on the conduct of person who contributes, he doesn't have to be, he participates, but he contributes to the commission of a crime. However, maybe that I will deal with that in my maybe next paper. Maybe I will deal with direct perpetration, joint perpetration of the organized criminal groups, because now I'm dealing more with someone who contributes to the commission of a crime by organized criminal group. But thank you for your question, and as I said, I mostly deal with individual cases of people who contributed or assisted in the commission of a crime by other groups. I don't know if it's a proper and satisfying answer.
Thank you, Aneta. Please.
Hi, one more question for Aneta. Sorry. Thank you, Aneta. My name is Maya. So on that regard, I think I was thinking about the Al-Hassan case. I think that yesterday we discussed a little bit about the Ansardine group in which Al-Hassan and Al-Mahdi before were both involved. And I think it's super interesting to see how there was organized crime involved with drug trafficking in Mali, and how that ended up in the ICC when that turned up into an armed conflict, right? So my question on that regard is, taking into consideration that we're talking here a lot about, for example, confiscation, and taking into account that the ICC wasn't able to identify nor recover, at least not recover one asset from the people that were convicted by the ICC, do you think that there are maybe tools that we can take from the local sphere to the international sphere, or it's dangerous in legal terms? Thanks.
Thank you. Also, another great question. Yeah, thank you also for the reference to the cases. I've heard about also those cases. However, I dealt with the responsibility of the main persons. When it comes to confiscation, I think that would be a bit maybe dangerous. I think any interference within the Rome Statute always arises some kind of questions and doubts, and but I guess that will be great. But I don't know in which kind of way we could regulate that, put the pressure for that tool. I don't know if it's.
Yeah, thank you very much. Okay, so we can stop here. Thank you very much. I'm very grateful, and thank you again. Thanks again to the organizer. It's time for coffee break.
It's a short coffee break, and then we are running a little bit behind schedule because of some organizational reasons. But if you can come back around in 20 minutes, it will be fine, so that
Yeah, 20 minutes.
we can start the next panel. So for
Yeah.
those joining online, we will start in 20 minutes again for the next panel. Thank you.
Thank you very much. Thanks indeed.
Thank you.
Okay, good morning. Welcome back. We are ready to open the third session of the 13 Young Penalists AIDP Young Penalist Symposium. The third session related to organized crime, criminal procedure, and international cooperation. We have the first panel on organized crime, digital dimension, and criminal procedure. This panel will be opened by my colleague Luan Bai from Southern University of Political Science and Law in China. Luan is my colleague of the AIDP Young Penalist Committee, and she will be introducing this panel that will be chaired by Alice Giannini. She's a professor of criminal law at Maastricht University and secretary also of the AIDP Scientific Committee. So, Luan, I don't know if you can hear us.
Yeah, I can hear you.
The floor is yours. Thank you.
Thank you, Emanuele. Good afternoon, everyone. I'm Lu Yuan, and on behalf of the Young Penalist Committee, it's my great pleasure to welcome you all to this first panel of the third session of the symposium. As Emanuele introduced, we are here today to discuss a dimension of organized crime that is no longer just emerging, but already reshaping it from within, its digital evolution, and the profound consequences that it has for the very foundations of criminal procedure. Over the past decade, we have witnessed a paradigm shift. Organized crimes have undergone a transformation that is less about changing motives than about revolutionizing its methods. The core illicit markets remain, for example, drugs, people and weapons, and illicit finance, but the how has been utterly transformed. These activities are now orchestrated through encrypted platforms, facilitated by biometric techniques, and coordinated across borders and digital speed. What used to be physical, hierarchical command structures have morphed into decentralized, data-driven networks operating seamlessly across the online and offline worlds. In response, states and international organizations have been compelled to adapt in kind. We are now in an era of AI-driven analytics, large-scale surveillance, automated interception tools, and interoperable databases. Cross-border cooperation mechanisms are becoming faster. In this context, digital evidence has become the linchpin, not only in cybercrimes, but also in almost every major investigation. But what accelerates investigative effectiveness can also destabilize our established procedural guarantees and assumptions. Let's take a digital interception. The paradigm shifts the paradigm of authorized surveillance targeting a specific suspect is being replaced by tools capable of capturing entire ecosystems of communication, often without clear territorial basis or individualized suspicion. Operations like EncroChat and SkyECC are prime examples. While the value of such evidence is undeniable, its legal admissibility forces courts to confront fundamental questions. We must rethink core doctrines. It's no longer sufficient to ask whether evidence is formally lawful. We must also ask whether our concrete concept of legality is equipped to evaluate methods that operate beyond traditional visibility. It's precisely this conceptual mismatch that explains why these new tools do not fit neatly into procedural frameworks built for a world for territorial jurisdiction, physical warrants, and case-by-case oversight. Evidence can now circulate globally faster than a defense team can mount a challenge. This brings us to the international level, where cooperation have become both a powerful enabler and a significant stress test for procedural principles. Mutual legal assistance treaties, joint investigation teams, and fast-track evidence channels have drastically reduced the time and formality for cross-border evidence sharing. But here lies the dilemma. The very mechanisms that facilitate access to data can also undermine jurisdiction guarantees. The evidence circulates through cooperation mechanisms. Its admissibility is often accessed not by how it was obtained, but through presumptions within the cooperation framework itself. This creates a gray zone where evidentiary power becomes transnational, where procedural guarantees remain nationally confined. In other words, effective cooperation nowadays require not only coordination of powers, but also the coordination of safeguards. And we can see similar procedural weakness emerging in other domains. And all of these developments lead us to a simple but profound question for the future of criminal procedure. Can our procedural guarantees still function when crimes are committed in the cloud and evidence is stored in distributed servers? And how can criminal procedure retain its constitutional function to protect against state power when investigative tools operate at a scale and speed that outpaces traditional judicial oversight? This panel will tackle these questions from multiple angles. Our aim is to explore the difficult parts to recalibration, that how technological innovation and procedural legitimacy can be balanced. And in such a symposium dedicated to responses between traditional and innovation, I think this panel perhaps embodies that tension most sharply. To guide us through the conversation, we are honored to have with us our chair, Dr. Alice Giannini. And with that, it's my pleasure to now hand over to Dr. Giannini to introduce our panelists. The floor is yours. Thank you.
Thank you so much, Luyan. I hope you can all hear me well. It's a shame I cannot be there with you. I am now in Nuremberg. Actually, behind me is courtroom 600. I am attending the Nuremberg Forum. So I'm there with you, let's say with my heart, but also in a very meaningful place right now. I will be very brief because we're running late and I know this is the panel before the lunch break and that is very sensitive. I will not add much to the great introduction by Yuan. I want to thank the great organization of Unitelma, Professor Gullo, Emanuele, and everyone on the Young Penalist Committee. I'm sure it's been a very successful symposium. I will be a very strict chair because of the time, so I would like to remind the panelists to please stick to your 10 minutes or else I will have to, let's say, get into the conversation and interrupt you. And the last point that I would like to share with you is that Besides my role as the secretary of the scientific committee of the IDP, I'm also the president and one of the founders of the Dutch Young Penalist group, which also includes Dutch members, not just Italian members. And we have the pleasure to host the next Young Penalist Symposium, which will take place in Utrecht in the 9th and 10th of April 2026. We will share more information after the end of this symposium, but we're very excited for this, and we hope to see many of you also in Utrecht next year. And with this, I will stop talking and hand over the floor to Lorenzo. I know that Lorenzo is a postdoc researcher in Luxembourg and also a visiting scholar at Columbia Law School. I don't know if you are in New York right now, if you are not yet, or you have been, very exciting. And Lorenzo will present us a paper discussing digital justice and organized crime, remote participation as a real procedural enabler. So Lorenzo, you have the floor for the next 10 minutes. Thank you.
Thank you. Thank you so much, Alicia, for the kind words. I want also to thank you very much, like the organizers, the IDP, Young Penalists, and UnitelmaSapienza for the invitation and the hospitality. So I will try to share my slides right now. So I will ask you kindly if you can confirm that you can see them. I hope so. Okay.
Yeah.
So yeah, thank you again. So it's a real big pleasure to be here. And since time is running, I'll get straight into it. So my starting point is then when we talk about digitalization of criminal justice, we usually think about efficiency, modernization, cost reduction. But when this happens in the realm of organized crime trials, I have the feeling that digitalization takes on like a very different meaning. And these are trials that, let's say, stretch the limits of procedural orthodoxy and normality, like where defendants are often detained in high security facilities, where the logistics are complex, or where the courtroom becomes a space for, so to say, risk management of the defendants. And video conferencing in this context isn't just, I would say, a technical aid. It becomes like a structural part of the process. But when we replace physical presence with a digital one, I have the perception that we are not just changing like the medium, the tool we are using, but we are reshaping what justice, what criminal justice feels like in this very specific framework. So the question that moves my research in this field is, can a remote presence ever carry the same normative weight as physical one? And starting with the European Convention on Human Rights and the European Court of Human Rights, the court itself seems torn, based on my research, between two compelling interpretative models. What I call normative equivalence and what I call tolerable difference. We all know about Marcello Viola versus Italy, very famous case, mafia-related case, in which the court accepted remote participation even when it was imposed against the defendant's will. But the court did so under two strict conditions: that the measure had to pursue a legitimate aim, in that case, public safety, and that the measure could not undermine due process. And here I see what I call the logic of tolerance. Digital participation is not equal to physical presence here, but its shortcomings can be tolerated when justified and proportionate. And it's a sort of defensive approach, let's say, grounded in necessity, not in principles. And by contrast, I observed that when remote participation is the only means available, the court moved cautiously towards a logic of equivalence. In those situations, digital participation is not a derogation from fairness, but a sort of a vehicle, a tool to preserve fairness. And here I'm thinking about cases occurring during the pandemic or certain cross-border proceedings in which the defendant cannot move freely from a state to the other. And there, video conferencing was the only way to ensure a hearing could take place at all. And I'm referring here to Bivolaru number 2 versus Romania or Dischkausen versus the Netherlands. And in these contexts, the court tends to treat digital and physical presence as functionally comparable, assuming that the conditions for effective participation are met. But my argument here is that this equivalence to me is fragile and, let's say, conditional, because most organized crimes proceedings still fall under the tolerance model, where video conferencing is imposed to manage risk or logistics, not to facilitate access to justice. And that's why the court keeps reiterating that physical presence remains the golden rule, the default expression of the right of fair trial, and remote participation is the exception. The danger that I see here is that this sort of tolerated exception slowly morphs into a sort of normality. Organized crime defendants become the procedural testing, in my opinion, for digital justice, and tolerance, if, let's say, institutionalized, might quietly become equivalence by habit, let's say, not equivalence provided by the convention itself. Now, the danger that I see here, and I move fastly to ULaw, the danger that I see in the ECTHR approach on digital participation is that the more serious is the crime, the thinner becomes the presence of the defendant before the court or before the jury, provocatively speaking. So moving to ULaw, the landscape is again here, I would say, fragmented. We have a directive on the presumption of innocence and the right to be present at trial that says nothing explicitly about remote participation. Typically in ULaw, when we think about digital participation, we refer to the 2000 MLA Convention and the 2014 EIO directive that encourage video conferencing in cross-border cooperation. And in practice, to be honest, this has become the default mechanisms in complex cases, including large organized crime networks or financial crimes. There is a recent case decided before the Court of Justice, FP and others, that confirms this approach. Remote presence is allowed when national law permits it, and provided that fair trials are respected. But the court, and this is my interest here, the court avoided any statement of equivalence between physical and digital presence. This ambiguity, let's say, remained unresolved. There is also a pending case, Bisilli, preliminary ruling from the Tribunale di Firenze, and it's another organized crime proceeding. Maybe that case might push this farther because the Advocate General Rantos already delivered an opinion saying that the EIO could even replace an EAW to secure the defendant's remote participation, consider that this aim, ensuring participation, is not the only purpose for issuing the EIO, but also the necessity to collect evidence. But to me, let's say here comes a paradox, because ULaw seems more comfortable, like letting technology, let's say, fill the gaps left by legal fragmentation. But the problem here is that different member states have different safeguards, different notions of what present is, what presence is, what participation is, and also different technological infrastructures. And in cross-border cases, this creates some sort of asymmetry, okay? And the European Union tried to address these loopholes. You all know about this new regulation 2044 on the digitalization of judicial cooperation. This promises to introduce some sort of uniform standards for video conferencing in cross-border criminal cases. It even talks about consent. The idea is that the participation should always be voluntary, not imposed by the state. But if we look closely, and this is again my take on that, the regulation's focus is overwhelmingly, I would say, efficiency driven. It's about interoperability between systems. It doesn't really empower the defendants with some defense rights. And that's why, despite its potential, I think that it risks reinforcing some sort of functionalist vision of digital justice. Another vision that prioritizes efficiency over fairness. And I'd argue that we're standing probably, again, on the edge of this paradigm shift. For decades, we have assumed that fair trial rights were tied to physical space. Think about the right to confrontation, witness, the right to be present, the right to participate. But unfortunately, or fortunately, I don't know, the trial is no longer confined to a courtroom. It's a sort of despatialized. And this requires, in my opinion, a new grammar. And I come to my conclusion. So we can no longer talk probably about digital participation as a mere extension of digital presence, especially in organized crime cases. The equivalence model didn't hold, nor does the tolerable difference approach, in my opinion, which suggests that minor losses in fairness can be, let's say, accepted for the sake of efficiency. So I want to conclude with few proposals. I would like to see whether we can agree on reframing the right to be present online as a genuine fair trial right, not just, let's say, a logistical option. I think that the right to be digitally present must include the ability to see, to hear, to interact fully with the proceedings and with counsel. The second proposal, provocatively, I want to make is that the use of remote participation should become a defense right, should always hinge on the informed consent of the defendant, because the risk is, on the other hand, that we are seeing remote participation imposed very, very frequently by default, without a thick assessment of whether fair trial rights are encroached upon or not. And thirdly, following the 2023 European Union Declaration for Digital Rights, I would like to propose that the EU should develop a coherent charter-based approach defining digital participation standards across member states. This is probably the elephant in the room. We have different standards of participation, different standards for digital participation across member states. And in organized crime trials, the stakes couldn't be higher, I think. These are the very cases in which our commitment to fairness, let's say, can be seen under pressure. And I want to conclude with this quote from Jose Saramago that once wrote, "Perhaps only in the world of the blind will things be what they truly are." And it's up to us, I think, to ensure that digital justice doesn't become that word. Efficient, connected, of course, but blind to humanity and corporeality of criminal proceedings. Thank you so much for your attention.
Thank you, Lorenzo. Thank you so much also for being in time. You make my day as a chair. I will immediately hand over the floor to Dr. Karolina Aksamitowska, who I believe is in the room. She's a lecturer of international law at Tallinn University in Estonia. And today she will present her paper on the role of new technologies and cooperation frameworks in fighting organized crime on Europe's external borders. Thank you so much. Karolina, you have the floor.
Thank you so much for your kind introduction. I hope you can hear me. And I'm so happy to be here in this beautiful city of Rome, also at Unitelma University. And I would like to congratulate the organizers, Emanuele and everybody from AIDP, for coming up with such a diverse and interesting program. I think this is such a great opportunity for young researchers to come together and to exchange research ideas. So it is a great pleasure and honor to be here. And I'm also jumping right away into the content of my presentation. Can I change the slides myself? Yeah, okay. Here. Sorry. Okay, so first I will talk a bit about the border situation, because I want to focus on transnational and international crimes on EU's external borders, of course, because of the time limitations and because of my background of being Polish and working in Estonia. I will focus mainly on the eastern border of the EU. Then I will move on a bit to what the history of using this type of data is in international and transnational criminal investigations. And then I will talk a bit about the potential challenges. I think because of the huge IT reforms and IT revolution that we're going through right now with the development of AI and stronger cooperation, more information sharing, I think I have more questions than answers at this moment. But yeah, I'm looking forward to the discussion. So starting with hybrid threats. I think this is the buzzword that we all know right now. It's potentially overused, especially with regards also to the eastern border in some places. But we cannot deny the fact that there might be, and I think the EU also doesn't deny that and includes this term more and more often, with regards to this phenomenon of instrumentalization of migrants, right? So we have this definition that I think has become more and more known nowadays, and this includes the situation where there's actors, the third country or hostile non-state actors. The action also includes encouraging or facilitating movements. We have the intention, right, to destabilize. Very vague, but I think we can understand what destabilization means in the context of a situation that has not yet reached the threshold of an armed conflict, but it's somewhere there in the gray zone, as well as the last factor of the intensity, that is the action that may objectively put at risk some national security. This is the official definition of instrumentalization, and it has already been elaborated on and used in a couple of instruments. We have seen also the distinction that has been made between instrumentalization and the situation of, for example, migrant smuggling, right? As we know, migrant smuggling is this procurement in order to obtain directly or indirectly financial or other material benefit from the illegal entry. And the EU has also distinguished the situation from migrant smuggling and the situation of instrumentalization if there is no aim to destabilize the country, right? So with regards to instrumentalization as a hybrid threat, we have, if instrumentalization exists in some situations, it's one of many different hybrid threats that we are facing on the eastern border. So, every day there are different types of cyber attacks. So there are situations of, cutting all these submarine cables, electric cables, as well as communication cables, massive disinformation campaigns. So in that context, taken by itself, where we have some migrants crossing the borders, it doesn't seem to be that serious. Obviously, it is something that happens on all of the EU borders. However, taken as a whole, if you have these types of attacks happening almost every day, then this is something that, of course, gives rise to some concerns. Sometimes they are unfounded, but sometimes, in situations when you have attacks also on some military, personnel members, there were some deaths on the border, there were some weapons used. It doesn't, of course, yet reach the threshold of an armed conflict, but it gives rise to concern. And I think when we're looking at the IT reforms that are going on at the same moment and are being rolled out. Of course, they're planned already before, but we know that technology will play, and it already plays, a very important role in the investigations that are happening both at the border and that are happening inside, and that includes international criminal investigations, as well as just ordinary crimes investigations, as well as terrorism-related offenses and ordinary domestic crimes. And here are just a list of a couple of reforms in the EU border management and IT systems that are happening alongside all of these hybrid threats that we are facing on the external borders. We have the screening regulations, that impose the screening obligations on the EU borders. We have the Eurodac recasts that also broadens the scope of the databases, allows the law enforcement and Europol compare some requests. We have broader asylum and migration biometric information exchanges. We have the entry-exit system that I think already started rolling out around this time, and is of course going to be more extensive and is going to be more developed in the near future. We have new changes to the Schengen information system, the visa information system. All of this, I think we can imagine, is going to play a very, very big role in the investigations and information sharing on the EU borders, referring to people who are, coming into the EU, but who also might have a criminal background in, for example, transnational or international crimes. So this is just an outline of the reforms that are taking place. And by 2026, we're going to have integration, all of these common repositories of biometric information that is collected from all of the people that are crossing through the external borders. We have all of these shared biometric databases that will be used not only by the immigration authorities, but also by criminal authorities. And the reason why I'm mentioning this, and I want to mention the potential of all of these different databases in international criminal investigations, as well as transnational criminal investigations, is that we already have the domestic experience and the many, many years of actually expertise of domestic criminal authorities, war crimes units, counterterrorism units that have been using these asylum databases. They're, of course, not the EU external borders IT systems that we're talking about right now, but the asylum databases in their own countries for the purposes of investigating terrorism-related crimes, as well as international crimes like genocide, war crimes, and crimes against humanity. So we know that this system actually really feeds into these international criminal investigations, this type of information from the immigration authorities, biometric information, photos, videos, user-generated content. It has also been, in many cases, confiscated as a part of the asylum procedure, or has been discovered after the asylum procedure in different countries like Germany, Netherlands, Sweden, and so on and so forth. This information has already been used in cases and as a result in convictions for, both transnational and international crimes. So we know that it can happen and that there is already the domestic expertise in this field. But now, of course, we're going to see much more information exchange and much more, in general cooperation on the regional and possibly international level. I think there is a very, very big potential for, many investigations being initiated already from the information obtained at the moment when the person enters, crosses the external border of the EU. It will be harder and harder because of these novel technologies and the information exchange to actually hide, as a war criminal, as a person who is a smuggler, as a person who, maybe committed terrorist offenses in the past. And of course, this entire system of using this type of information dates back, I think, to the years 2014, 2015, when many states in Europe have understood that some of the asylum seekers and migrants that are coming, sometimes also refugees coming from, areas such as Syria and Iraq, might have been also foreign terrorist fighters who are fighting in Syria and Iraq, and maybe fighting for ISIS and other terrorist organizations there. And they have decided to really harness the potential of technology in order to, make sure that these people, get the justice that they deserve, even though some of them have obtained asylum in different countries in Europe, and that they get, get a trial, and sometimes in some cases are put behind bars for the core international crimes and transnational crimes that they have committed, sometimes through, cumulative prosecutions for terrorism-related offenses and war crimes or crimes against humanity or genocide. So we know the system works domestically, and we know it the way it sort of started. And now the question is, how is it going to, develop in the in light of all of these new systems that are being rolled out? We also know that the role of all of these EU agencies and institutions is also growing exponentially. We know that Frontex, it's an organization that is responsible, of course, for monitoring the borders and helping states whenever they request it. They are also envisaged to assume an even more central operational role. They are helping to roll out some of these IT systems, as well as they will, of course, there's mentioning of their, potential role in like surveillance through, helping counter some of the drone threats and things like that. So it's both encountering national security threats, as well as in rolling out all of these border management systems. We already know that Europol and Eurojust have also received increased powers and increased, mandate to store information, to store evidence, to preserve evidence. Some of these types of crimes, they're also going to facilitate, investigations probably in the future, thanks to these increased powers, as well as thanks to increased, information that we will have from all of these systems. And also we have more and more, of course, new accountability hubs, not only in The Hague, but also in different places. Joint investigation teams have played central role in these investigations dealing with international of years, and very, very often, the success of these joint investigations, a very strong cooperation with immigration. In terms of opportunities and challenges, I think
Carolina, may I ask you to conclude, please?
Yes, of course.
Thank
These
you.
are my conclusions. So yeah, this technical capacity definitely translates into opportunities. There will definitely be some evidentiary challenges, but I think we can learn from domestic experiences. There's, of course, the concern about the rights of the migrants, because they will be subjected to very, very intense scrutiny, or they're already subjected to intense scrutiny. So there are human rights concerns, and I want to end with that human rights should not be, overlooked in rolling out these new IT systems. And thank you all.
Thank you so much, and apologies for my interruption. I will immediately leave the floor to Dr. Maria Crippa. Dr. Maria Crippa is a postdoc researcher at the University of Milan. I believe she was also recently in the neighbor city of Tilburg for a visiting stay, and she will present today her paper on prosecuting transnational and macro crimes, digital evidence, judicial cooperation, and fair labeling across borders. You have the floor, Maria.
Thank you, Alicia, for your kind words, and thank you to the organizer, AIDP, Young Penalist, and UnitelmaSapienza for hosting us, and for allowing my participation online. I'm currently in Berlin for research on the topic I'm presenting. So I'm very happy to receive feedback on this paper. I hope you can see my presentation. Okay, good. My focus is today on the challenges that international prosecutions and investigations on macro crimes, meaning also international crimes, and transnational organized crimes pose, and what do they have in common, what kind of challenges they bring before procedure, and also substantial charges of international crimes. And I can see that, as you can see as my take on this research, I found 3 different layers of problems that are very well interconnected. The first one is the kind and volume of evidence. The second one, the judicial cooperation mechanisms. And the third one, coming back to national jurisdiction, how these crimes are prosecuted in the judicial practice. And I will use the case study of crimes against migrants committed along the Central Mediterranean route. I chose this particular topic because it can show both the commission of international crimes, meaning crimes against humanity and possibly war crimes against migrants, and also, of course, transnational organized crimes, human trafficking and smuggling. Going straight to the first of these problems, it has already been mentioned in the introduction that information technology, of course, have an impact on how these crimes are committed, and the consequence also in how investigations needs to be conducted at the international level. We have all in mind how the use of mobile phone data, but also social media has increased in witnessing and bringing evidence for the commission of international crimes, microcrimes, but also transnational organized crimes. This has not only been done by victims and witnesses of crimes, but also on the side of perpetrators, and, for example, the use of social media in filming the commission of war crimes by the IDF very recently. The use of drones footage or the GPS locations, for example, in the case of crimes against migrants in the Central Mediterranean route and the interceptions at sea, but also the resort to automated weapon systems where the human part is only at the final moment of the decisional process that lies upon a machine. This, of course, very briefly, we don't have the time to go into details, but of course, this brings questions on how this evidence across borders and digital evidence is collected, managed, and brought before courts, with the risk, of course, of manipulation and with the aim to not violate the provisions that have been put in place both at domestic level and international level to ensure admissibility. I put here only one of these provisions, Article 69 of the Rome Statute of the International Criminal Court. And of course, it is important to also recall the fact that this evidence doesn't have to infringe the defense right to a fair trial. At the international level, I believe that these macro crimes also had an impact on the development of new mechanisms. International databases are already mentioned before, and especially, I would say, since the aggression by Russia to Ukraine, we have witnessed a new way to store evidence and new tools that have been developed before the ICC, for example, the OTP link database that was implemented also with the help of external providers such as Microsoft, and now with the US sanctions to providers to the court, of course, brings into question the security and feasibility of such instruments. And Eurojust, the core international crimes evidence database that was put in place under Regulation 838 of 2022, which relies mostly on the role of national authorities. All these databases have been put in place after the war in Ukraine and with the aim to be applied to other situations. However, it is not clear how they do storage and use evidence also for other situations. So I put also here concern of transparency in their use. The response to this first layer of problem was the enhancement of judicial cooperation mechanisms. Joint investigation teams and joint team has already been mentioned before. They have different legal bases. We can come, of course, back to this in the Q&A. They have different functions, but the main idea is to provide a direct contact between national authorities and law enforcement agencies in the collection of evidence when these crimes are committed cross borders. They cooperate with international actors with different degree. I would say when we look at, for example, the joint investigation teams, we see that there is a huge support by Eurojust. these joint investigation teams mainly relate to transnational organized crimes, money laundering, drug trafficking, but also smuggling and human trafficking. And also war crimes such as international crimes, such as in the case of Ukraine. I focused very much on the joint team on Libya, which was put in place under a different framework, so the UN Convention on Transnational Organized Crimes, the Palermo Convention, to bring high-level suspects of human trafficking and smuggling from the Horn of Africa through Libya to Europe. And again, here there were some concerns that can be raised with regards to the transparency, the right of the defense to access information during investigations, and to cooperation that was perceived, especially in interviews with Dutch prosecutors, as one way with the OTP of the International Criminal Court. A third very important instrument is the Mutual Legal Assistance Convention, the so-called Ljubljana The Hague Convention that was finally drafted and signed in 2023 after a long work done by the MLA initiative. Unfortunately, not yet ratified and signed and ratified by Italy, but the aim here is still to strengthen the cooperation between national authorities for the prosecution of international crimes. And this regime is very much derivating from other instruments, such as the Palermo Convention or the UN Convention on Corruption, or instruments under the Council of Europe against for mutual assistance and on extradition. The consequence of this mutual cooperation is that judicial initiatives that put together prosecutors among different national authorities and with the support of international institutions prove very effective. I'm referring here, for example, to the case of the joint team on Libya. We have cases in the Netherlands and in Italy, but they have a limit, which was already highlighted in different under different topics, also by Lorenzo before, which is the fact that national authorities, national jurisdictions has their own rules, and this is also true in the way these crimes are labeled. We can see a high reliance on offenses that relates to border control, for example. So the application of offenses related to smuggling and over more complex definitions, for example, human trafficking and crimes against humanity even. But the same pattern can be applied with regards to the couple terrorism versus war crimes charges. We see a huge reliance on terrorism charges instead of applying war crimes. This is something that can be witnessed at the domestic level, for example, in Germany, the Netherlands, France, but also in Italy. We do have war crimes in our military codes, and we see that the Court of Cassation is more keen to apply these kind of the terrorism charges instead of war crimes, for example, in the cases of the occupied Palestinian territory. With regards to the case of migrants, in my research, tried to put into context two different systems, Italy and the Netherlands, very different in terms of the fact that the Netherlands has prosecutorial discretion, while Italy have an obligation, a duty to act with regards to the notitia criminis. But in the end, the same results can be drawn from these cases. The Netherlands have provisions on universal jurisdiction, have International Crimes Act, but in the end applies mostly human smuggling instead of international crimes provisions. And the same goes for Italy. We have very broad application, extraterritorial application of Italian criminal law, and through the use especially of smuggling offenses, this is something that takes off all the other offenses that can be applied, for example, torture. And concluding, both transnational organized crimes and macro crimes, of course, nowadays demands a complex and even more complex cross-border investigations and, of course, relating to digital evidence that are difficult to collect and to store and manage before being brought before courts. And in this sense, I think judicial cooperation proves especially feasible and important when cases are not immediately going to trial, for example, in the case of Libya. However, the effectiveness of these tools in terms of accountability and of the possibility to address macro criminality and is the fact that judicial practice, both at the international and domestic levels, apply the correct labeling of such crimes, meaning transnational organized crimes and macro crimes over ordinary offenses. Thank you.
Thank you so much, Maria, for your enlightening presentation and for respecting the time. I will immediately leave the floor to our next speaker, Joaquín Collen Paunero, who is assistant lecturer at Buenos Aires University and criminal attorney in Buenos Aires. You have the floor. Oh, wait, you will present your paper on massive judicial hacking and the right to a fair trial, reflections based on the EncroChat case. You have the floor.
Thank you very much, Alice. And I would also like to thank the AIDP authorities for organizing this symposium. This is my first time presenting on an AIDP Congress, so I'm very happy to be here. And also, I believe I'm the only speaker from Argentina, so I feel a special responsibility to represent my country and our long-standing tradition in safeguarding procedural guarantees. So first of all, I would like to point out that due to the time restrictions, I will only be able to outline the key topics from my paper. Therefore, I'm going to briefly explain what the EncroChat case was, and then explain a few of my concerns regarding the right to privacy and the right to a fair trial. I'm aware that many of my fellow speakers have referred to their specific domestic legal frameworks, but my approach will be more theoretical, as I aim to offer a critical perspective rather than a normative one, and especially given that the symposium brings together participants from, I believe, speakers from nearly 18 countries, so each with distinct legal traditions. So, okay, I'm going to briefly explain what the EncroChat case was. Many of you might already know. But in 2017, the French gendarmerie discovered that organized crimes networks operating in France were using a secure phone network called EncroChat. And this system guaranteed complete and traceability and absolute discretion, both in its encrypted interface and in the devices themselves. These were devices specially modified, so they didn't have cameras, microphones, GPS, or USB ports. They also featured automatic message deletion and other functions that were specifically designed to quickly erase any kind of sensitive information. So in 2020, the French and Dutch authorities, with the support of Europol, formed a joint investigation team, and they later managed to hack the EncroChat system by inserting Trojan software, harvesting and transmitting to a data hub controlled by the French authorities more than 120 million messages from about 60,000 users worldwide. And what's concerning is that this was done without individualized suspicion or case-by-case judicial review, and with no time limit for interception. The joint investigation team informed several EU and non-EU member states to their law enforcement agencies that had decrypted the EncroChat network, and after which many states requested access to the data. So of course, the French authorities then kind of distributed this evidence. However, they refused to reveal the technique used to hack the system, alleging it was protected by military secrecy. And furthermore, defense attorneys have alleged that they were only provided with Excel spreadsheets containing extracts of the chat messages, but without access to the underlying raw data or the corresponding digital chain of custody. So, regarding the privacy concerns, traditionally, the right to privacy guarantees the secrecy of private communications, subject only to lawful and necessary state interference. Most of the countries that I studied, including countries from Latin America and from Europe, allow targeted hacking only under certain specific conditions and after obtaining judicial authorization, because it's considered an ultima ratio measure that, of course, severely compromises privacy. Therefore, the prosecution must present evidence to demonstrate that the measure in that particular case strictly follows the principles of necessity and proportionality. But on the contrary, in this kind of mass hacking, investigative authorities seize a massive number of messages from all its users and then went kind of fishing for proof of crimes. So this stands out as a major attack on privacy, where no prior evidence is needed to access personal messages. Now, authorities claim that this was a unique case that needed extraordinary measures. However, up to 40% of the people affected may have used the service for legal purposes. This is why many scholars argue that this kind of operation blurs the line between legitimate state hacking and unlawful mass surveillance. So legitimizing such operations sets a dangerous precedent for future large-scale hacking campaigns, potentially authorizing generalized surveillance powers under the guise of fighting organized crime. And yet, even if one accepts that there has been a breach of the right to privacy, then there's a crucial question that remains. Can prosecuting authorities lawfully rely on evidence obtained through measures that disregard privacy altogether? Of course, I believe the answer is no. And then regarding the right to a fair trial, there are many concerns that I have, but I would like to focus on two. First, there's the secrecy issue. Equality of arms requires the prosecution to disclose to the evidence the method used to gather evidence. Nevertheless, defendants were denied the right to know how evidence was obtained, and therefore the right to challenge the method used. And please bear in mind that this is of extreme importance in cases regarding e-evidence, because as you may know, evidence can easily be tampered with. Moreover, authorities from requesting countries defended that argument, saying that they basically trusted France had obtained the evidence according to their own legal framework. But transparency ensures defendants can examine whether evidence was obtained according to the applicable legal standards, and challenge its admissibility when those standards were not followed. That is why I believe that denying full disclosure of that method should render the evidence inadmissible. And secondly, there are some forum shopping concerns. Prosecuting authorities may carefully select which countries will conduct an intrusive measure based on where it is permitted, allowing them to bypass their domestic applicable procedures. So basically, through international cooperation mechanisms, such as the European Investigation Order, France distributes the evidence gathered, and then local courts, based on mutual trust, decided not to re-examine the hacking. In conclusion, massive hacking has emerged as one of the most innovative methods used to obtain evidence, and of course with the potential to replace other traditional investigative tools. But so long it has been used in ways that are controversial at best. And the debate around this topic revolves around the classic tension between effective prosecution and procedural safeguards. And in this context, I believe that the rule of law becomes a guiding standard for new legislation. Thus, it is crucial to establish a legal framework regulating the conditions under which this method can be used, including proportionality, necessity, and transparency, among others. Thank you very much for your attention.
Thank you very much, Joaquin, for your presentation, and also thank you so much to respect the time. And I will give the floor now to our two next speakers, Dr. Michele Pisati and Dr. Maria Elena Santucci, who are respectively postdoc researcher and PhD researcher at the Università Cattolica del Sacro Cuore in Milan. And they will present today their paper on digital evidence, organized crime, and the implementation of the new UN Convention against Cybercrime. Michele and Maria Elena, you have the floor.
Thank you. Thank you also to Emanuele and your team for the great hospitality. It's an honor to be here for me and my colleague, Dr. Santucci. She will conclude our brief presentation, spending few words on the digital dimension of investigating and prosecuting organized crime in Italy. For my part, I will only try to skim the surface of the implications in this area of law of the new United Nations Convention against Cybercrime that will open for signature in the next weeks. We have little time, so I want you to walk away from here with just some few key points. The first key point is that despite its name, the new Convention against Cybercrime scope of application goes far beyond cybercrime and includes, and now I quote the preamble to the Convention, also the fight against offenses related to transnational organized crime by promoting a regulatory framework on the collection and the cross-border circulation of digital evidence in this area of criminal law and criminal procedure. In my opinion, that's not surprising. We heard in the previous presentations that digital evidence is of paramount importance in the world of combating organized crime that proliferates in cyberspace. The EncroChat case, as we heard, proves it. And even the United Nations themselves are working on this for, I think, since at least Article 20 of the Palermo Convention in 2000 that provides the power of authorities to use electronic surveillance to fight against cybercrime. So the fundamental question is, what's new with the new UN Convention against Cybercrime? In my opinion, the major novelty is the alignment of the UN legal framework with the most advanced standards regarding digital investigations and personal data protection entailed by the Budapest Convention of the Council of Europe against cybercrime and its protocols. And here is the second point. Organized crime investigations may benefit from the advanced mechanisms that are regulated in Chapter 4 and 5 of the new convention that are largely inspired by the Budapest Convention of the Council of Europe. And for example, real-time collection of data, traffic or content data, rapid preservation of stored electronic data, and interception of communication. But I think that the most important thing about the new convention is that, as stated recently by the European Data Protection Supervisor in its opinion of 2025, in the new convention of the United Nations against Cybercrime, we can find the absolute first reference to data protection in the UN legal framework dealing with cooperation in the criminal justice field. The first reference. This means that UN states should ensure the compliance of digital investigation with some fundamental principles that are legal certainty, judicial review, and proportionality, regardless the nature of the offense, meaning also for organized crime. What's more, in the proceedings related to organized crime, states may refuse to transfer personal data if that cannot be done in compliance with their domestic law protecting personal data. And I think about the high level of protection of EU member states, but I think also at major issues for the cooperation with states that do not provide so high level of protection. Truth to be told, many authors outlined that the safeguards enshrined by the new convention are not so binding because the margin of appreciation of states is so wide, and then this can result in discrepancies and difficulties. That's clear, but I think that the implementation of the convention, that is still a global convention, is a unique opportunity to steer the debate concerning the fair balance, and we heard in the previous presentation, the fair balance between the protection of personal data, both of the accused and third parties on one side, and on the other side, contrast to serious crimes and, above all, organized crime. This is a profound question that comes into place especially as law enforcement authorities embrace the use of new technologies and big data to fight organized crime. For example, the European Union facilitates access also to passenger name records, to traffic data or other information coming from social networks or online platforms when organized crime is at stake. And what makes everything more complicated is the combination with AI that is used widely in this field of criminal law. It's not a coincidence that in the new European Artificial Intelligence Act, there is a specific use of real-time biometric identification system for organized crime. So what we need, and also what my colleagues outlined, is a paradigm shift in the light of the novelties we will face in the implementation of the new convention, both an international legal framework and in a national legal framework, in particular in Italy, as my colleague, Maria Elena, will explain. Please, Maria Elena, the floor is yours.
Thank you, Michele. Italy is a member of the United Nations, the Council of Europe, and the European Union. So the Italian legal framework serves as a testing ground for the implication of the UN Convention on Cybercrime in addressing the digital dimension of organized crime. Italy has long been at the forefront of the fight against organized crime. After the tragic mafia massacres of the 19th, our country has introduced a special legislation which derogates from the ordinary rules, notably to facilitate the collection and exchange of digital evidence in criminal proceedings. Such double track is evident in the field of communication interception, where the broader legal conditions for criminal groups have allowed a wider use of these measures, including the deployment of sophisticated spyware, a practice subject to strict procedural limits in ordinary criminal cases. However, when it comes to cybercrime and the digital transformation of organized crime, Italy faces serious challenges. In fact, many investigative activities still rely on procedural rules designed for a pre-digital era, which are no longer adequate to today's digital environment and international legal framework. This gap has raised several systematic questions, exemplified by the XIII decision of the Italian Supreme Court. For example, how can we reconcile traditional categories with the new form of digital evidence? Or how can judicial cooperation work when the data must be obtained through measures that are not regulated under Italian law? So the United Convention on Cybercrime can offer a unique opportunity to address these questions. In fact, under the Convention, as Michele said, states are required to provide adequate conditions and safeguards to ensure that any collection, use, or cross-border exchange of digital evidence fully respect fundamental rights, including the protection of personal data. This issue is particularly pressing in investigation involving criminal groups, where the risk of a disproportionate intrusion into fundamental rights is increased. In this context, it is necessary to enhance Italian legislation. This is crucial to ensure that any implementation of the UN Convention on Cybercrime fully respect and complies with the higher standard of European Union. And in fact, Italian legislation is not aligned with the European case law, which require that any access to data stored in digital devices must be limited to clearly well-defined offenses, must be compliant with the principle of proportionality, and must be subject to a prior judicial or independent review. In this regard, the UN Convention...
May I ask you to conclude, please?
Yeah. In this regard, the UN Convention on Cybercrime can offer a unique opportunity to guide the ongoing reform on these issues and to enhance the jurisdictional guarantees in Italy. And at the same time, the international legal framework can offer also an opportunity to regulate the new technology not yet regulated under Italian law. Thank you for your attention.
Thank you very much. Again, my apologies for the interruption. I will now introduce our last speaker, who will present a double paper, but I believe only Ciro is present in the room, and Ciro Costa Chagas is a PhD candidate at the Federal University of Minas Gerais, and he will present a paper written with Enrique Abi Aker Torres on provisional disposal of seized crypto assets, regulatory gaps, and the risks of anticipating criminal sanctions in international context. Ciro, you have the floor.
Good afternoon, ladies and gentlemen. First of all, my sincere thanks to the organizing committee for this excellent event. For me, it's an honor to now offer a few brief of my ideas. So, just a second. Okay. So, like I said, my theme is the provisional disposal, often the early sale of seized crypto assets. I will treat it is as a doctrinal question at the intersection of digital assets, non-conviction-based confiscation, and organized transnational crime. The core issue is not logistics, it's the limit of state power when managing assets before education. Like you see, my structure is simple. We will start with the legal nature, and then legality and limits, risk and ex ante proportionality, organized crimes and cross-border coordination, and finally, a consistent set of minimum parameters. Let's keep going. Okay. First of all, the legal nature of the measure is instrumental. A patrimonial precaution designed to preserve value and secure outcomes. It is an asset preserving, not punitive. That distinction matters. If the rationale drifts from preservation to punishment, we get, like I said, that distinction matters. If the rationale drifts from preservation to punishment, we get an anticipation of sanction effects, a de facto penalty before the merits. In non-conviction-based confiscation settings, this temptation is stronger because proceedings may advance without a conviction. Precisely for that reason, safeguards must be thicker and judicial control more exacting. Conceptually, we must ensure the measure does not prejudge guilt and remains reversible in substance. Legality and limits. Coercive patrimonial measures demand, like I said, strict legality and a stable taxonomy. Authorities must point to a clear statutory basis and to the exact doctrinal category they are using. No analogy in malum partem, like civil rules or perishable or hard to maintain goods, cannot expand criminal coercion by analogy. Procedurally, we need an adversarial and reasonable order, timely notice to the defense, the possibility to contest valuation, timing and market assumptions, and a decision that explains why less restrictive options are insufficient. These requirements maintain the boundary between precautionary administration and punitive sphere. Risk and prognosis. Volatility is not a justification itself. It is an empirical input that triggers analysis, not an automatic permission to liquidate. The correct test is ex ante proportionality, treatability, necessity, and fair balance asset at the moment of decision without ex post rationalizations. The state bears the burden to substantiate concrete custody risks, liquidity constraints, and the unavailability of milder safeguards, secure custody, hedging mechanisms, or partial liquidation when truly indispensable. Early sale should remain exceptional, precisely because it may produce irreversible sanction-like effects. Organized crime operation are, like you see on the other presentation, cross-border, platform-mediated, and intermediary-heavy. That reality raises two needs. First, coordination, mutual legal assistance, recognition of orders, and interoperable procedures to avoid fragmentation across agencies and jurisdiction. And second, the most important on this theme, auditability, end-to-end trails, chain of custody, valuation records, sale instructions, and execution logs. These measures, data loss and fraud, support legitimacy in non-conviction-based contexts and allow later review. In short, the more complex the organized crime attitude, the stronger our documentation and oversight must be. Finally, a concise blueprint, a narrowly tailored reasonable order with genuine defense participation from the start. Public and testable technical protocols for custody, valuation, and execution, including contingency planning for market stress and operation failures. Accredited execution platforms with temper evident logging and ex post, like I said, review. The aim is simple: preserve value, creating de facto confiscation or eroding legality. These parameters also enable the cross-border cooperation that organized crime cases require, while maintaining doctrinal integrity. So, conclusion, a provisional disposal is not merely administration. It structures the risk of anticipating punishment. With strict legality, adversarial procedure, and auditable execution, we can preserve asset value, protect due process guarantees, and still enable effective action against organized and transnational crime. That's it. Thank you very much. I'm happy to take questions.
Thank you very much, Ciro, and thank to all the speakers. I believe it is very hard to be so effective in such little time, so really congratulations. I would say now we open the floor for 15 minutes, and let's see if some questions come from the in-person public.
Yes, one question is coming.
Thank you to all the speakers for their presentations. And I have a question in particular for Lorenzo. I was very interested in the focus you put on the notion of consensus, and I was wondering if you could elaborate a bit further on how you propose to measure such consensus, on what standards, because we know that, for instance, especially in organized crime cases, it is quite often a matter of de facto negotiations between also feasibility, like there's no resources to bring you in person in court, because moving a person that is under security restrictions, especially high security restrictions, might be cumbersome. Therefore, you voluntarily accept to maybe rather participate remotely to the trial. So how would you propose to measure consensus in a way that it is really free consensus and not just another way to get forced consensus in this sense? Thank you very much.
Thank you very much, Julia, for your question. And I think that this is maybe one of the topics that I couldn't have addressed in just 10 minutes. You know, this topic should have merited, let's say, another presentation, but just to be brief. So I really agree with you. I really see your point that consensus will become, let's say, a turning element in this discipline, because of course, we have to be sure, I agree with you, we have to be sure that the consent of the defendant will be given like freely without any sort of coercion against him or her. So the first thing that comes to my mind is that, for instance, consensus shall be given in an unequivocal way, being the defendant brought, for instance, in special rooms. I'm thinking about prison facilities, for instance, in which the defendant can talk with his or her lawyer and can consult about many the many opportunities that would occur whatever the consent is given or not. This is just one thing that comes to my mind. The second thing that I can think about is, again, which kind of consensus can a defendant give if that defendant, for instance, doesn't really understand the language of the proceedings, or maybe that defendant has been, I don't know, prosecuted in absentia because he didn't know before about the trial, and suddenly he has been or she has been arrested and brought to the prison, and then he has to prepare his or her defense in very short time while deciding whether to attend, I don't know, the habeas corpus hearing in person or online. And again, I think that here, when it comes to effective defense rights conception, I think here really we shall think about the best way we have to give that person the full toolbox of defense rights, including, for instance, right to interpretation. For me, it will be very hard to think that a person is giving consent to attend online if we are not sure, for instance, if the person understands really the language of the trial. So here, maybe I can think first, special room arrangements for this kind of defendants, special facilities for them to talk with their lawyers or the interpreters, and secondly, ensure that them are really enjoying fully all defense rights. Contrary-wise, the EU is just relying on the conception of consensus that relies internal national frameworks that are fragmented again. So we also have to reflect maybe conclusively on that the very meaning of consensus is not even harmonized so far. So my proposal is that maybe we can agree on minimum standards for me being special facilities and effective enjoyment of defense rights, and maybe we can move forward. But for the time being, I pragmatically see it very hard, for member states to agree on a shared definition of consensus. So I would say these two elements, as at least the minimum elements that should surround the element of consensus here, especially in organized crime cases.
Are there any other questions? I don't see the audience, so.
Yeah, there is another one.
Great.
Thank you. I would like to thank for all of the performers for very interesting papers which are being in the connection with our deliberations from yesterday, especially for the last panel. And I would like to ask the question to two of performers. Firstly, I would like to ask Jocelyn about the issue of admissibility in Argentinian criminal proceeding, admissibility of using so-called fruits of poisonous tree, because you mentioned that question that law enforcement may be using such information which are online, of course, gathering online with breaking some sorry, with in more or less unlawful, right? Because we have some safeguards which must be breached. And I have also a question to Carolina, which is connected with the proposing new control systems. As I mentioned yesterday, there is a risk, especially to using artificial intelligence to create codes to hacking IT systems. So every IT system is endangered to be hacked, to be manipulated. Do you know what measures are planned, or it's even concerned to protect that entire system of biometric identification of foreigners outside from the EU? Thank you.
Hello, thank you very much for your question. In Argentina, at least to my knowledge, we only had one case related to the EncroChat hacking, and it was related to a band called Los Monos, which is one of the biggest criminal bands of Argentina. And these, sadly, our court didn't really analyze the procedural safeguards from the defendants, but rather they had a similar argument to that of many countries of Europe, for example, of Germany, when analyzing the admissibility of evidence. The argument was, okay, this evidence came through the legal international cooperation mechanisms, so we trust that France did this hacking according to their own legal framework. Therefore, what the court said is, we are not going to reanalyze, to re-examine this hacking and render the evidence admissible. And once again, because the evidence was brought into the procedure through the international cooperation mechanisms. That is why I think that we should pay a lot of attention to the international cooperation mechanisms, especially to the mutual legal assistance treaties, and then analyze what happens to the countries that are not part of, for example, the joint investigation team in this case, and how can we kind of find balance between the legal frameworks, so that the evidence that the joint investigation team gathers can then be admissible in all of the countries, and especially taking into account that these kind of measures have extraterritorial effects, because in the case of France, they obtain evidence regarding messages that were sent between people in Argentina. So I hope I answered your question.
All right, so I'll just briefly reply about the issue of the AI and the storage of all of the biometric information, as well as the use of AI to falsify the biometric information, because that is another problem, right? So there is a really good report by Europol on the vulnerabilities in the biometric system, so I highly recommend everybody to check it out if you're interested in this. I'm sure that there is a lot of risks that will be addressed, but there's lots of risks that will continuously have to be addressed, because as we know, the transnational organized crime is also, ahead of the, technological game as well. All of the smugglers networks are, of course, using, technology in order to enable the smuggling. So the EU really has to be, at the forefront of these efforts. And there's, so many different risks that were outlined, including, deep fakes, creating fake fingerprints through AI, creating fake, voices and fake facial, in general, the facial element. So all of this is definitely there. And yeah, I'd recommend to look at the report.
I would take maybe one last question.
Okay, if there are other questions, maybe? No? Okay.
So first, maybe back to Joaquin, because the question is not about practice, but about the law. The question is the Argentinian Code of Criminal Procedure or other acts regulating criminal proceedings has provisions which explicitly refers to issue that you may use illegal evidence at proceeding or not. Because in Poland, for instance, in Poland, we are regulated that issue. Yes, and generally you may use illegal evidence. Some exceptions, but generally it is admissible. And the question is about Argentina, or because as I understand, it's mainly results not from provisions, but from the practice, right?
Alice, maybe I missed your question, or before giving the floor to Joaquin?
No, I was just asking if there was a last question, but I see that there was a follow-up question, so I would ask Joaquin to reply in a few minutes, and then we close the debate.
Thank you, Alice.
No, we do not have a specific legal provision about that, but we have some Supreme Court precedents, but we do not have precedents from the Encrochat case. We have similar cases, which, in my opinion, if we apply the same principles, the evidence should be rendered inadmissible, but no legal provisions.
Thank you. I don't see the room, but I would say maybe it's time to close the debate. And I would like to thank all the speakers and all the public for the questions. And yeah, it was a pleasure to be your chair. And I hope to see you next year in Utrecht or somewhere else around the world. And I wish you all a very pleasant lunch break.
Thank you very much. Thank you, Alice. Now it's time for lunch. The lunch will be offered, of course, always outside the main entrance, and please try to be back at 3 p.m. in order to be on time for the last two panels. Thank you. Okay, I think we can start again for this second panel of the second session of the AIDP Young Penalist Symposium on the EU role in the fight against organized crime. David Marco, due to a last minute issue, cannot be here with us, but the panel will be introduced and chaired by Giulia Lasagni, who is Associate Professor of Criminal Procedural Law at the University of Bologna. So please, Giulia, the floor is yours, and thank you very much for being here with us.
Thank you very much, and let me start first by welcoming who's still resisting, regardless of the very nice weather here in Rome, to talk about fight against organized crime and criminal procedure at this time of a Saturday afternoon, and most importantly also by saying thanks to the organizer of this event, Unitelma, the AIDP, the Young Penalist, and above all I would say Emanuele, because he really made this all possible, and I hope I'm not disregarding someone in the organization, but on behalf of all of them, I thank Emanuele once more for his organization. So in these panels today, we continue a bit the discussion that was open in the previous panel, looking more at procedural aspects of the fight against organized crime, and all the presentations that are going to tackle the matter today in this panel, they all have some, I would say, common trends that I think are very indicative. That was coming up as a surprise, if you want, because that was the title, and then there were proposals of the topics, and they all indicate what are the main challenges that under procedural framework the fight against organized crime, and not only organized crime, is today posing. And I would say, first of all the presentations from different perspectives will reflect upon the difficulty and perhaps the inadequacy, we're going to maybe discuss about that, of traditional criminal procedure investigative methods in tackling such transnational phenomena. There is more and more the worrying about whether criminal procedural safeguards are enough to counterbalance the opening towards new investigative measures. And there is, again, also more and more a question of what new or what borrowed investigative measures we should apply now within the domain of criminal proceedings in order to be efficient in investigating such crimes. So there is the development of new forms of cooperation, perhaps giving more role to the private parties. How exactly, that's a matter to discuss. There is looking at administrative investigation and techniques, and seeing to which extent we can include them in the investigative criminal procedure framework. And at the same time, of course, this all opens a lot of problems and questions concerning the holding of procedural safeguards and the fairness within criminal investigations and proceedings. So our panelists today are going to discuss about the matter, all from different perspectives. I'm just briefly introducing them, and then I will give them the floor. We will start with a presentation by Jeunes Pènalistes from the Ghent University. He's assistant and PhD researcher at the Faculty of Law and Criminology, and he will address this broad topic from the perspective of Europol. Then we will have two presentations, both focusing from different angles on the EPPO, so the European Public Prosecutor Office. We're going to have Nicolò Di Paco, that's postdoctoral researcher in criminal procedure at University of Torino in Italy. And we're going to have Daria Zeliko from the Faculty of Law in Zagreb, Croatia, where she is holding a position as a research assistant at the chair of criminal procedure law. And then we are going to finish our panel with a joint presentation. And I thank you very much, the speakers, for having agreed to put together their expertise on the matter. Joint presentation by Benedetta Righini and Chloé Fauchon. Benedetta Righini is a PhD candidate in international and European law with a joint program, Marie Curie program among the universities of ULB, FGV, and Louis. And Chloé Fauchon is a lecturer at the UPPA University in France. And they are going to tackle the problems of fighting against organized crime under procedural perspective with regard to third parties. So I would say without further ado, I would leave the floor to our first presenter, Vannes. I beg the pardon of all the speakers because for sure I'm mispronouncing names, so apologies very much for that. And I remind just our speakers that according to the instructions received, we have 10 minutes each, so please stick to the timing so that we can have some time for discussion later on. So Vannes, thank you very much for joining us online, and I leave you the floor with a presentation entitled Europol and its Criminal Information Hub, Pushing the Limits of its Mandate. Thank you very much.
Thank you very much for this introduction, and I also would like to thank those attending this panel. And sorry, that was okay. So now we are at the right slide and no longer at the wrong. So I'll just share the presentation as should be. So I would like to kick off with this one. I hope most of us have heard about the Commission's initiative to make Europol a fully operational agency. And perhaps it's time for us to wonder, where are we now with Europol if it's not a fully operational agency? And is it possible, if we assess the situation where Europol is currently, to shift towards this fully operational agency, or are we already pushing the limits of its mandate? My presentation should, okay. So when we are thinking about the limits of Europol's mandate, we could easily turn to Article 88 of the Treaty on the Functioning of the European Union and conclude Europol is a supportive agency, has certain specific allocated or predetermined tasks, and we could check it from that perspective. However, we could also look at it from another angle and say, what competences does Europol currently have, and what is the autonomy that Europol has on the basis of these competencies to determine what is able and what is not possible for the agency at present, and then to look a step beyond, because we could say one's autonomy can be based upon the law, but if there was no entity seeking you to hold you account, then there might be more autonomy than is determined in the law that might be applied. And then, of course, that could turn us to a conclusion on whether or not Europol is pushing the boundaries of its mandate. But of course, when we look at Europol's competencies, and particularly those part of the Europol Criminal Information Hub, then we can subdivide these across three pillars. These three pillars are collecting information, connecting information, and providing information. And of course, these three pillars might be easily to pinpoint to some extent, but I'll briefly explain them. Collecting means all the information that is coming to Europol. Connecting is what does Europol do when it has the information, and the providing pillar is giving information either back to the member states, back to EU agencies, private parties, or the public in general. When we look at the collecting pillar, we see that Europol can receive information from member states, third countries, EU agencies, EU databases, such as SIS, VIS, ETIAS, ECRIS, TCN, EAS, and then we have private parties with the newly amended 2020 Europol regulation. We see that Europol can now address the dissemination of terrorist content, extremist content, and child sexual abuse material. Europol can also collect information from the internet, will, following the adoption of the 2025 amending Europol regulation, also be able to receive information from immigration liaison officers, and can, following the 2024 Prüm 2 regulation, also look into national databases, but also before that one, it had already access to the PNR data based upon the 2016 PNR directive. So that being the collecting pillar. And of course, I want to be clear, this is not a limited list. There are more sources from which Europol can collect information. And then we resort to the connecting pillar. Europol can connect data subject categorized data, but can also process non-data subject categorized data. It could do so for a long time, but now for the first time, it has a very explicit and properly defined mandate. Then already since the Danish protocol, Europol could process data to check its relevance and, if so, determine its purpose. But now with the 2022 amending Europol regulation, Europol can also, together with the member states, have joint operational and analysis cases. And finally, Europol has become a major player, apologies, for exchanging data. And we have seen this particularly following the adoption of the 2023 Information Exchange Directive, saying that the main tool to exchange information will be Siena, Europol's own developed information exchange tool. And then, of course, we finally have to resort to what can Europol do based upon these collected and connected information, and that being the possibility to write reports, both operational and strategic ones, being able to request member states to open investigations, a competence that was recently expanded following the 2022 amending Europol regulation. And now Europol can also propose SIS alerts, can include persons on the ETIAS watch list, give opinions thereon, as it can do so regarding visa applications. It has also its decryption platform, it can deploy guest officers, and since 2015, Europol has its own European Union Internet Referral Unit. So when looking at all these competences and all these abilities it has, we should perhaps wonder, yes, but first of all, we could look into the responsibility, which has in itself increased significantly. But also then the question is, what about autonomy? How much can Europol itself decide? And while if we read in other literature, some of them believe that Europol has become this NSA, this massive player, and that it has exceeded its limits. Well, if we look more in depth, we see that from a collecting perspective, Europol has increased its autonomy, but it remains highly dependent on the member states, because when member states provide information, when Europol consults EU databases, national databases, or others, member states often have to consent, first of all, to obtain the information, and secondly, to process the data. But furthermore, regarding the other sources, Europol will often have to inform member states, we have information that might be of interest to you, duty to notify. When we look at the connecting perspective, okay, Europol has shifted from a predetermined computerized system to a currently purpose-based approach. But if we look more in depth, that does not differ that much from what we might assume, because in the past, Europol had we have the analytical working files, and there was 24 in 2011, and a couple of months later, it were only 2, because it revised the entire structure thereof, demonstrating that also at that moment in time, Europol had some autonomy to determine what it could and would not do within its data processing structure. Europol also can process non-categorized, non-data subject categorized data, but that is a competence that was already foreseen in the 1998 Council implementing decision on the AWFs, so already included partially in the 1995 Europol Convention. So that also did not change that much. The fact that it now has an elaborated framework does not rule out the fact that it already existed, showing that there is not that significant increase in autonomy. And then when we look at the providing pillar, okay, Europol has obtained some autonomy, and it is also an increase. But when we look at the two important elements, or two most important competencies, then we could think about the ATS watch list, allowing Europol, in contradiction to the proposed CIS alerts, to introduce persons on the ATS watch list, but in fact, it remains dependent on the member states on whether they wish to comply. Similarly, with the European Union Internet Referral Unit, we see that it can inform member states or refer data to private parties and say, we don't think this is in compliance with your terms and conditions, but in the end, it remains dependent on the private parties whether to comply, whether they comply with it or not, demonstrating that it has no actual operational autonomy, but only some kind of supportive autonomy. So then, of course, we could turn to, okay, we have this autonomy, and then we might think, okay, this autonomy should be counterbalanced. And as I mentioned previously, there is this idea that Europol has turned into some kind of an NSA, but these are all the entities that in a direct or indirect manner can hold Europol to account over its finances, to its processing, to its political accountability, demonstrating that there are several entities. And I think that while I could say something about each of them, I think the most important thing is that Europol is mainly held to account, but as we have seen, the providing pillar offers Europol some new and innovative competencies, and these differ from the collecting and the connecting pillar, as they also go alongside with increased responsibility, therefore raising the question, can we maintain the situation that Europol staff enjoys immunity, except for when they participate in JITs? And when we see that from our collecting perspective, that Europol receive much and much more information, then of course the question is, can it distribute this information in a manner that will be acceptable in every member state? Meaning an issue of mutual admissibility. So it could be time to let Europol or the European Union decide on certain particular norms for a mutual admissibility framework. So when we conclude on this presentation, I think, yes, there is a significant increase in competences over the past 25 to 30 years, but the increase in autonomy is, in fact, fairly limited. But there is still a suitable accountability system with certain shortcomings, except for the immunity and the mutual admissibility. As a result of this, we can in fact conclude that there is still significant margin for improvement to achieve this operational Europol, still within the limits of its framework. Thank you for listening to my presentation.
Thank you very much, Wannes, for having raised the issue of accountability towards also the other institutions and member states. And of course, that also has an impact then on the people and the parties that are involved in proceedings in which such data then it is used, and for also having stick to the time limits. So thank you very much. Now, without further ado, I leave the floor to Nicolas for his presentation entitled Administrative Freezing Measures and EPPO Proceedings Between Efficiency and Protection of Fundamental Rights. Thank you.
Thank you. Good afternoon to everyone. Good afternoon to everyone. First of all, I would like to thank the organizer, the committee, and particularly Emanuele Birritteri, for the opportunity to take part in this event. Turning to the conference subject, the EPPO 2024 annual reports provides valuable insight into the EPPO activities relating to organized crime and recovery of assets stolen from the EU budget. Firstly, the reports demonstrates that investigation into organized crimes are the core of the EPPO activities, operational activities. Actually, the report itself acknowledges that the criminal organization realized that investing profits from the criminal activities would enable them to launder significant sums into the legitimate businesses. However, as the reports also highlights, in several member states, these criminal activities were and still are poorly detected, scarcely investigated, and rarely prioritized as an important area of crime to combat. Regarding the freezing measure set out in Article 13, paragraph 1, letter D of the EPPO regulation, it is worth noting the disproportion between the value of the asset frozen and the total estimated damage to the EU finance. As for the 31 December 2024, there were 2,666 ongoing investigations with an estimated total damage amounting to 24.8 billion. However, at the request of the European delegated prosecutors, the competent authority issued freezing order only for 2.42 billion, while the value of assets actually frozen during the year amount to just 849 million. This reflects the difficulties that the competent authorities encounter in tracing and recovering assets. These difficulties mainly result from recovery operation being carried out too late and from the inability to block the transfer of the assets. Therefore, the risk is that once that the EU budget is affected by the organized crime, it will not be possible to recover what has been subtracted to the EU budget. In light of these difficulties involved in preventing the dissipation of the assets through the conventional criminal measure, as set out in the EPPO regulation and accessible to national judicial authorities, the prospect of exploring alternative instruments that could offer faster and more effective safeguarding to the EU assets is appealing. After all, an increasing number of national and supranational legal instruments provide administrative authorities the power to freeze assets related to criminal activity to ensure a rapid and efficient intervention. It is sufficient to recall Article 24 of the Sixth Anti-Money Laundering Directive, which established that member states shall ensure that the FIUs are empowered to take urgent action directly or indirectly where there is a suspicion that a transaction is related to money laundering or terrorist financing, to suspend or withhold consent to that transaction. In other words, the FIU can halt the execution of a suspicious transaction to carry out its financial control and give the judicial authorities the time to order the appropriate preventive measure. Consider also the Financial Action Task Force recommendation, in particular the recommendation number 4, according to which countries should have measure, including legislative measure, it's important to underline including legislative measure, to enable their competent authorities to suspend or withhold consent to a transaction. As for the Italian system, Article 6, paragraph 4, letter C of Legislative Decree number 231 of 2007 come to the fore. The provision allowed the Italian Financial Intelligence Unit to suspend for a maximum of 5 days suspicious transaction, and the only limitation is that the suspension must not prejudice any ongoing investigation. It is essential to note, and this is a very critical element, the general lack of prerogative for the interest parties. The regulation does not impose generally any information to be given to the recipient or for adversarial procedures to argue the existence of the measure prerequisite and respect of a formal procedure. There is also no general provision for legal remedies such an appeal or at least an opposition. In this regard, it's true that Article 24 of the Sixth Anti-Money Laundering Directive established that the member state shall ensure that the FIUs exercise the function subject to appropriate national safeguards, such as the possibility for the person whose transaction has been suspended to challenge the suspension before a court. Nevertheless, the provision apply only if the national law lay down a period of suspension or withholding exceeding 10 working days. Proceeding further in our analysis, consider also Article 4 bis of Legislative Decree number 109 of 2007, which empowers the Italian Minister of Economy and Finance to adopt national freezing measure pending the adoption of the designation measures ordered by the United Nations. The freezing issued by a decree on a proposal from the Comitato di Sicurezza Finanziaria, the Financial Security Committee, lasts 6 months and is renewable. It is based on the perpetration or attempt perpetration of acts by individual, legal person, groups, or entities with the purpose of terrorism or financing program for the proliferation of weapons of mass destruction or threatening the international peace and security. Well, several critical aspects arise vis-à-vis this kind of measure. First, it is potentially sine die. There is no maximum duration or maximum number of extension, meaning that the authority could proceed with an indefinite series of periodic renewals. Furthermore, as the freezing measure issued by the FIUs, it is characterized by the inadequacy of the information, participation, and defense right, and by a judicial shortcomings. Now, clearly, such administrative measure produce results that are comparable or even greater than those of the freezing or seizure measure ordered by the judicial authorities. It is undoubted that this kind of measure may be quicker and more effective, but they come at a serious cost to fundamental rights. Let's say the quick question is whether surrendering to administrative efficiency is also inevitable in the context of EPPO proceedings. There be granted administrative authorities the power to freeze assets involved in PIF crimes, or whether it is possible to design alternative criminal solution that strikes a balance between the protecting EU financial interest and respecting the fundamental rights. And from the legge ferenda perspective, one could consider introducing a measure directly applicable by the European delegated prosecutors to secure assets at risk and prevent their dispersal. The idea is to create a temporary and fast freezing order lasting 72 hours that ADP could use at the first scenes of a PIF offense to block any operation, transaction, or conduct that could be harmful for the union assets, thereby protecting the EU budget. And once the definitive loss of EU assets had been averted, the ADPs could carry out appropriate investigation to determine whether a crime has been committed and request or order a conventional criminal measure. The instruments could be modeled, of course, mutatis mutandis, on the immediate action provided by Article 11, paragraph 2 of the Directive on Asset Recovery and Confiscation, namely the action that may be taken when necessary in order to preserve the property until a freezing order has been issued. At this point, 2 final remarks are necessary. Firstly, the effectiveness of the measures, particularly with respect to the freezing bank transaction and organized crime, relies on a widespread real-time monitoring of current account and transaction. And a similar power was initially provided for by Article 26 of the proposal for the EPPO regulation, but as Julia has highlighted, this was removed to the pressure of several delegations which consider it an excessive step toward the harmonization of criminal procedures. In any case, a comparable form of control is feasible. Consider, for example, Article 28 of the Directive on a European Investigation Order that allow for a European investigation order to be issued for the monitoring of banking or other financial operations that are being carried out through one or more specified account. Secondly, and finally, since this will be a measure carried out by an ADP in the context of an EPPO proceeding, the person affected by it shall be granted all the rights referred in Article 41 of the EPPO regulation, including the right of defense, right to information, right to access to the case material, right of access to a lawyer, the presumption of innocence. They shall also have the right to obtain a judicial review under Article 42 of the EPPO regulation. And it is precisely in light of these safeguards that in my opinion, criminal action should be preferred to the administrative procedures. Thank you.
Thank you very much, Nicola, for this proposal and for having also again pointed the light on the problem that is, if we want to extend the safeguards of criminal procedures, then we want them to be effective, how to do that and how to achieve so. However, it's a matter for challenges. And we continue to discuss about challenges with our third speakers, Daria, that will discuss a paper about the obstacles the EPPO faces in fighting organized crime in participating member states with rule of law deficiencies. So, Daria, please, the floor is yours.
Thank you. Can you hear me firstly?
Yes.
Okay, perfect. Thank you. So I also want to thank Julia for her kind introduction. Also warmly, as other speakers, congratulate really the Young Penalist Committee for their hard work, which really show off. And I'm really sorry that I couldn't join in person in beautiful Rome. Anyhow, as per the topic of my presentation, as we all know, the EPPO was initially not imagined nor constructed as some kind of a European rule of law protector or defender, but with the aim of offering protection to financial interests of the Union. So at first glance, it seems that EPPO has little or even nothing to do with the protection of the rule of law principles, besides itself being bounded by it. However, we all witness that, depending from our member state that we come from, that during an operative period of the last 4.5 years as European supranational prosecutorial office, first of its kind in the world, it became increasingly evident that the EPPO confronts different institutional, I would say, legislative and operational barriers of a systemic nature while prosecuting organized crime in some of the member states that have in common, unfortunately, grappling with a judicial system backsliding, low public trust in national judicial bodies, and all this coupled with high-level political corruption. So, for example, in 2024, the Civil Liberties Union for Europe, which is a cohort of different European NGOs, identified several EU member states, all of them participating in the EPPO in alphabetical order. Those in famous states are Bulgaria, Croatia, Italy, Romania, and Slovakia, as intentionally undermining the rule of law, and by doing so continuing a troubling liberal path, which was long associated and still is with Hungary, but also with Poland until the change of the government, as we all know. The interesting trend, which was already noticed and monitored by the academia, is that the EPPOs, through the action of the public actions of the chief European prosecutor, Laura Kövesi, proactively resisting the instances of the rule of law backsliding in participating member states. So actually, already upon the presenting of the first EPPO annual report, she noted inter alia how the EPPO is the first in line of defense of the endangered rule of law in the EU. Such bold statement, in my opinion, also reflects her privileged position for the assessment of the efficiency of fairness and national prosecution, judicial and law enforcement systems of participating member states. But then I ask myself, what is the legal basis for any of her action or reaction? And those are actually recital 16 and article 4, paragraph 2 of the 2021 conditionality regulation. This is the acronym of this primary EU source. And the mentioned regulation, which was really much discussed in the literature, the EU has, in my view, finally established a legally binding mechanisms with the potential to act as a financial stick against member states that seriously resist and oppose the rule of law. In a way, this newest rule of law instrument formalized the EPPO indirect involvement in monitoring adherence to the rule of law standards. And however, the EPPO is not alone, but I would say that among the institutions which are enlisted with this Article 4, it is definitely the most proactive institutions, at least proven so far. So I noticed various instances over the years where the EPPO actively opposed signs of the rule of law decline in some of the participating member states, especially, as I said, in relation to its troubled judicial or prosecutorial system. And those instances include, but are not limited to, already, for example, in the first year of its mandate, there was a problematic procedure of the appointment of EDPs in Slovenia. Then there were several problematic institutional appointments for European delegated prosecutors by, for example, Bulgarian and Italian government. Again, numerous problematic amendments to criminal substantive or procedural legislation for a couple of states, including Slovenia, Slovakia, and Austria. Recent administrative inquiry, we could all read about it. It was quite recent, into possible misconduct by Bulgarian European prosecutors. Then this is quite active thing, lifting parliamentary immunity in Greece. And in many countries, which was noted in the last annual report, hiring specialized investigators and lack of cooperation with local authorities. For example, in Croatia, the EPPO has not access to data of tax authorities, although the local national prosecutorial office has it. And especially sensitive proved to be a conflict of competencies cases. This was also quite a lot written about. And however, this is my question, by vigilantly performing this, in the end, quasi-monitoring function, is the EPP, or basically the chief European prosecutor, overstepping its mandate, as was quite vocally suggested by Croatian Prime Minister, also State Attorney General, in one of the cases, which I will briefly tell you about. And that was Croatian conflict of competence case that involved it was basically a highly sensitive political corruption case from November last year in health sector, which involved numerous influential persons and 2 companies, including now former Minister of Health. He resigned because of the case. And for those of you who are studying EPPO or come from Spain, case resembles the infamous Spanish Ayuso case. And in the paper, I will compare those 2 cases. So there were parallel investigations from the Croatian Public Prosecutor Office, Croatian Prosecutorial Office, and EPPO on the same matter. And actually, the underlying legal issue was that the Croatian implementing law on the EPPO institutionally designed that conflict of competence between the EPPO on the one side and National Prosecutorial Office is decided by the State Attorney General. And I must say that such legislative solution is not unique for Croatian legislation implementing law, but also it's present in 13 other member states, and it was unsurprisingly found to be inconsistent with the EPPO regulation itself in the Spark report from 2023, which was authored by European criminal law experts that include Professor Ligeti. And this hardly understood legislative solution in which the state attorney generals are decided as competent judicial body for resolving conflict of competence in light of this heavily evidenced democratic backsliding witnessed throughout the EU, can actually ultimately end up in giving green light to perpetuating obstructionism of national prosecution of fraud against the financial interest of the EU, and which is again against the whole idea why EPPO was founded and advocated for more than 2 decades. And I wouldn't go into much detail, but I will just say the case was settled in 3 days. Of course, it was given to the National Prosecutorial Office, and numerous deficiencies emerged in Croatian procedure, in which, and what's worse, even this State Attorney General was then elected, and he was heavily opposed in public because of his known ties to governing party. And he, in the end, as I said, unilaterally deprived the EPP of competence, invoking national legislation without any judicial scrutiny or procedural guarantees in the process. And this Kafkaesque, I would say, procedure was so absurd that the Koveshi said that she never encountered a case like this in her whole career as a prosecutor, so not only as a chief European prosecutor, but as a Romanian prosecutor itself. And of course, she warned the European Commission by writing a formal letter about worrisome systemic challenges in upholding the rule of law that occur and occurred in Croatia. And actually, I'll just mention that the newest saga, newest development in this constitutional saga is actually that the Croatian Constitutional Court recognized some constitutional gravity of the issue. So it asked preliminary reference to the Court of Justice of the EU by saying whether the State Attorney General may act as a judicial authority under the Article 25(6) of the EPPO regulation, but also ask interesting questions about the EPPO independence in the member state and its right to effective judicial protection, because there was non-judicial protection either for the EPPO or for the defense. So these instances that I briefly mentioned in this exposition underscore the EPPO, I would say, increasing assertiveness and the chief prosecutor's commendable vigilance in identifying and reporting any breaches of the rule of law, but also, as vividly seen on this drastic Croatian example, show the growing tension which was to be expected between, I would say, supranational prosecutorial authority and national resistance from the ground. And a bit to conclude, whether this enhanced role of the EPPO will continue to evolve and to what extent it will be met with compliance or resistance from member states remains a key question, in my view, for a future, successful future, at least, of this European criminal justice cooperation. And it also shows for the prosecutor untypically transparent style of Croatia, and it is yet to see whether the next person who will show, who will step in her shoes will as well be willing to expose any instances of rule of law backsliding, which have repercussions in the end to the functioning of the EPPO. And now I will finish because this, what happened in Croatia was really viral and it was the hot topic for almost a month. And I will finish up with reading her a statement from Laura Kovesi to Croatian media, who said, if I had to send a message to citizens now of Croatia, I would tell them that the country is civilized, the rule of law is fully respected. And the task of prosecutors in the EPPO is to fight the rule of law and against crime, which is not easy. There will be constant attempts to violate the rule of law. There will always be criminals who will try something. People will constantly be corrupt. But our main task is to fight against it, and we will do it the best as we can. So in the end, from the letter, it seems that she places the fight against financial crime and the erosion of the rule of law in member state on an equal footing. So grazie mille.
Thank you very much for your presentation that once more from a different perspective again brought up the problem of liability at the institutional level and the clashes between different ideas of liabilities and how to balance, where to find a common point between the need to be efficient in investigation, the need to find common standards, the need to protect the institutional settings in the different states, the procedural safeguards, and finding a solution. It's far from being easy, definitely. So thank you once more. And now, without further ado, I leave the floor to our last joint presentation that will tackle again some of these issues and other issues concerning the criminal challenges, the criminal procedural challenges in the cooperation concerning organized crime fighting, looking at the relationship between the European Union and Latin American and Caribbean agenda. So please, Benedetta and Chloe, the floor is yours.
Yes, thank you, Julia. Chloe is gonna share our presentation.
Yes.
She's gonna.
So,
Hi, Chloe.
Okay, so can you see? Oh,
Yes.
sorry, it's not the correct one. Sorry. Okay. Okay, first I would like to thank.
Chloe, sorry if I'm interrupting you. We are seeing just from the last slide. If you can share the first one.
Oh,
I don't know
really?
if you're managing.
Oh, okay.
Yeah. Okay, perfect. Now it's perfect. Thank you.
And sorry. Okay. Here it's okay.
Yes.
Okay, sorry. So first, I would like to thank the organizer of this nice symposium, and also for organizing such an event and on such an interesting topic, and of course because I accepted that Benedetta and I shared a topic and did a joint presentation. Then I would like also to thank Benedetta for accepting working with me and for being such a good co-worker. So, first I will speak myself, and then Benedetta will take the lead for the second part of our presentation. So first,
Claire, apologies to interrupt you. Just technically, they're telling me you should maybe share your screen, so then we can see the presentation in presentation mode, if that's possible.
but okay, sorry, wait.
That's quite all right.
Because well, let's see. Sorry.
Share the screen, yeah.
Okay, and then.
Yeah, perfect. Thank you
okay.
very much. Apologies for interrupting you.
I know, sorry, it's on my computer. It's okay, so I didn't know that you couldn't see. Well, as I said, well, as Julia said as well, well, we will be departing from the European territory and look at third states cooperating with the European Union to effectively tackle transnational organized crime. And my starting points, well, there are two starting points. From the one hand, well, we can say that transnational organized crime is evolving at an unprecedented pace. So it's not my words. It's a statement that Europol did well, at the beginning of this year. And because of this unprecedented and fast evolution, well, there is a need for the states, but also well, the international organization and the EU to adopt innovative strategies to have a real chance of effectively limiting well, the effects of organized crime. And
Chloe, many apologies. Are you going forward with the slides?
No, for the moment, no.
Okay, perfect. Then.
I'm sorry. At the same time, well, my second point, sorry, is that, well, organized crime, as everybody knows, well, doesn't know about borders. So, well, there is, of course, an obvious need for the EU to also find some third partners outside its territory. So that was our starting point, and that's why we will focus on an inter-regional cooperation, so with Latin America and the Caribbean, so called LAC. So as you can see now, I think on the screen, well,
yes, thank you.
Our presentation will be divided into 4 parts. So first, a quick overview of the current situation of EU-LAC cooperation. And then I will deal with its foundation, so why this cooperation and its framework, so how was it implemented. And then Benedetta will, will, let's say, dive into more concrete studies and some case studies on joint investigation teams, El Pacto program, and finally evaluate well, the current cooperation. So regarding the overview, well, if we look at the EU roadmap to fight drug trafficking and organized crime that the Commission issued in 2023, we can see that there were 17 actions that were considered of greatest importance, and they were organized by 4 priorities areas. And well, our focus is on the last priority area, which is to strengthen international cooperation, and most precisely on Action 15, which encourages the EU to boost its cooperation with countries in Latin America and the Caribbean. So the choice to use the verb boost, well, we need to understand from it that the EU has already developed some cooperation with Latin America and the Caribbean before 2023. And indeed, it's a cooperation that has been developed for more than 10 years, almost 15 years or maybe a little more. And for instance, in 2015, they were already adopting an action plan to well, tackle some points among them drug trafficking, money laundering, and other offenses related to migration. Then we can say also that in the EU, well, in specifically the Euro-Latin American Parliamentary Assembly, there is a specific group, a specific working group on security and organized crime. And in 2023, they made some recommendations. And among them, they asked the EU and LAC to adopt a comprehensive and global approach, and also, to give priority to the bi-regional mechanisms for political dialogue, technical and financial support, and also the transfer of best practices. So it's not only a legal agreement, it's further than that. So, this is the framework of our intervention, and the objective is to evaluate, as I said, the existing cooperation so that we can answer the following question: does the EU-LAC cooperation offer the global and comprehensive responses that are required to irrevocably diminish organized crime? Well, so first, as I said, I will focus on more theoretical points and then Benedetta on practice. So first, why is there a need for a special cooperation between the EU and the Latin American and the Caribbean? Well, we can answer this question with two main points. So first, because there are some specific offenses which are especially targeted in this cooperation. So, of course, I think the first idea that we can have is, drug trafficking, because, Latin America, has been for a long time, a place where drug is produced, and also where this drug is transiting then to achieve the European market, because the EU with North America are the largest destination market, for instance, for cocaine, but also other drugs. And despite being drug trafficking our first idea, we cannot disregard other offenses, such as trafficking in human beings, and also gold trafficking. It was highlighted by the EU agencies, and also, of course, money laundering, which is a special logical consequence from the crime I previously mentioned. And for instance, recently, there was an investigation supported by Eurojust and Europol, and it led last week to the simultaneous arrest in Colombia and Albania of 17 persons suspected of international human trafficking. So they were recruiting women in Colombia, and then these women were sent to Albania and sexually exploited. And the second main reason is that there are important connections between the Latin American networks, criminal networks, and the European ones. So from the EU, but also from the Western Balkans. And just to finish explaining what is so important that the EU collaborates and cooperates with Latin America. The Insight Prime, which is a research organization, in 2025 highlighted, and I'm quoting, that the strengthening alliance between the Latin American and European crime groups poses a global threat. So, it's a very important element. So, just to finish, regarding the actions that were taken already, we can focus on three categories of tools that you can see on the slide. So first, there are some working arrangements between EU agencies such as Eurojust or Europol and specific states of Latin America, but not the Caribbean. So, Latin America and the Caribbean are considered a block by the EU, but in practice, it's not real. There are two different regions with their specificities. And we can also mention the working arrangement that Eurojust signed with the AIAMP, which is the Association of Ibero-American Public Prosecutors Offices. And the second tool is that the EU funds some specific operations to effectively tackle some criminal activities. And for instance, the EU is participating with other partners to the Crime Just program led by the United Nations, and they're specifically funding joint investigation teams through this funding. And finally, the last one is that the EU is also implementing technical assistance programs with Latin America and the Caribbean. And it's impossible to mention them all, but I will specifically focus on El Pacto, which is a specific program launched with Latin America and the Caribbean. It was launched in 2017, and it's a technical assistance program and not a financial program, and nor a training program. So the idea is that practitioners can share their experiences and good practices. And so I will give the floor to Benedetta. We will explain you more in more concrete terms what is El Pacto. Thank you very much.
Thank you very much, Chloe. And I join you in the thank the organization of this conference and for this opportunity, and to thank you to be such a good co-worker. So as you saw, Chloe introduced very well what is the situation, the framework of the interregional relations between the EU and Latin American countries, underlining the fact that organized crime is clearly one of the challenges that the two regions need to tackle. And at the same time, we can see that there is kind of discontinuity in this cooperation between the two countries. In my second 10 minutes, I hope, I will explain two case studies that I decided to delve more into, which are the case studies related to the joint investigation teams between some EU member states together with some Latin American member states, and on the other side, the program that Chloe just mentioned, which is El Pacto. Why did I decide to choose these two instruments? Because these two instruments are really different. One is legal, like the joint investigation teams are based on agreements, and I will explain this later. And differently, El Pacto is a non-legal program. And on that, I'm sorry, you are all lawyers, but I think it's really important to delve into these non-legal instruments that are expanding a lot from the EU perspective with the other regions. So if Chloe, you can change the slide, I will delve into the joint investigation teams first of all. So the joint investigation teams are really important, and the interesting point of this instrument is that there is a multi-layered framework. So you can see that we have the provision on joint investigation teams at the UN level, namely the United Nations Convention against Transnational Organized Crime, but even the one against corruption and the one against drug trafficking delve into these instruments, and they encourage the possibility of states to make agreements between each other to tackle specific investigations. So we can have instruments at the international level, but even at the regional level, the EU has its own article 13 of the Mutual Legal Assistance Conventions concerning the joint investigation teams. And even in Latin America, we have Mercosur, who just approved an agreement related to the joint investigation teams at the Mercosur level. And then, of course, we have the possibility at the bilateral level. At the end, it's true that the international, regional, and bilateral legal frameworks cover a law in general on the joint investigation team, but the important thing of this instrument is that there is the national sovereignty of the state. So at the end, there is an agreement between two or more state parties to tackle a specific crime. And most of the time, this comes from a transnational crime, and most of the time is a transnational organized crime. And this is what is said by the Eurojust report related to the joint investigation teams. Concerning the EU and Latin America, we can see that there are already joint investigation teams settled up. I'm focusing on a particular joint investigation teams between Italy and Brazil. There are actually two. Why is it important? Because these joint investigation teams is also coordinated by Eurojust. Eurojust is a new agency, and it's interesting to see that the new agency is coordinating this project, and it's also actually financing this kind of agreement. On the second, on this point, we can see that these joint investigation teams was just, I would say, out. It was advertised by Eurojust at the end of September 2025, and you can see that there were like actually two actions. The first action was a cocaine trafficking between the 'Ndrangheta in Calabria and Brazil, and on the other side we had the Cosa Nostra network with Brazil and again Hong Kong. The interesting point of these joint investigation teams is that, first of all, is the only one that is advertised. I also asked to Eurojust officials, and of course I cannot disclose how many agreements are settled up, but it's interesting to see that this was successful. And for example, the important point that I want to make is that without the action of Eurojust, they don't think that this is going to be possible, because Eurojust functions as a connection between the two countries. For the moment, we have the only Italy-Brazilian connection, but we don't know if they're opening up to other countries. And for example, another action together with Eurojust, another organization that is helping setting up these investigation teams is ScreenJust. And before, I mentioned in the slides before, there is another joint investigation teams between much more than two countries, not only Brazil and Italy, but it was between also Serbia and the UK and the US. So you can see that they are trying to map out through this agreement that are made by the agreement of member states. So we are still on the national sovereignty. They are trying to fight against transnational organized crime. On one side, we have the joint investigation teams. On the other side, we have the action of El Pacto. And so, Chloe, if you can change, okay. El Pacto program is a really interesting program that I'm studying also for my thesis. And actually, this allowed me to delve into empirical research on the topic. It's a program that it's made, as Chloe said, on a base of technical assistance. So, how does it work? The European Union member states work through national agencies, and these national agencies offer technical assistance to Latin American countries that need to deal with transnational organized crime. As Clay well said, El Pacto started in 2017 with 19 million fundings by the European Union, and with the action of mainly 4 countries, Italy, Spain, Portugal, and France. Now, in 2025, they just started El Pacto 2.0, which received more than double of the fundings. Almost 50 million euros were on this program. And the Netherlands and Germany added to this project. What is the base of El Pacto? Well, why did they do that? Because basically El Pacto 1 was considered a successful experience. As you can see, the El Pacto 1 managed to create in Latin America the CLASI. I'm sorry, I didn't put I took for granted that you knew what was the CLASI. CLASI is the Comitato Latinoamericano of Internal Security. They reunited 7 countries from Latin America who managed to talk with each other concerning their security problem. And this is helping them to delving into investigations related to transnational organized crime. Then El Pacto helped also Latin American countries to create a network of penitentiary system. I'm not going to delve in deep into this, but Latin American countries have a huge problem related to security matters in their penitentiary centers, and mainly because narco-trafficking groups are very strong inside these detention centers, and they can control the crimes from outside, which is very similar to Italian past situation. And then the last good result of El Pacto was Eurofront, which is again another program related to the borders control. As you can see, El Pacto 2.0, I just added small things on that because it just started, but is mainly related to, again, informing the Latin American countries concerning new challenges on the issues. If you can change the slide. Okay, so that's just an overview of my empirical study. So I conducted semi-structured interviews with the youth agencies members who worked in El Pacto 1 mainly, but also in El Pacto 1 2.0. And then I also talked with the Latin American officials. And I think it's very interesting, the outcomes that they said, the Latin American officials, is that they appreciate the fact that they were not imprinted by the European Union, but they just received a technical assistance. And so they found out how to solve certain problems related to their communication, to the fact that they didn't know who the person responsible of certain of the operation was, and so now they know each other better. And on the other side, they also know the European Union counterparts. So the 4 agencies that are from the 4 countries that I mentioned are now contact points for these countries. And now I'm going to the conclusion, Chloe. In our paper, we're going to delve into a general evaluation of the EU-LAC relations. In my point now, I'm just going to delve into my doubts concerning these instruments, because yes, of course, as we all said, transnational organized crime is something to fight, but at the same time, as criminal lawyers, we need to remember that there are safeguards to be protected. And on that side, I had doubts on both, I would say on both instruments, because if on one side the joint investigation teams is true, it's an agreement, it's much longer, and also this is a critics that was moved from the people taking part of the joint investigation teams and from the doctrine, which is the length in concluding an agreement and the Eurojust role in trying to manage these agreements. On the other side, once the agreement is done, there is kind of a lack of control. Like, you don't know, it's an investigation, we cannot know, and I would say rightly so, but we don't know if there is any check concerning the fundamental rights standard in advance and during, and basically this allows a policeman from Brazil to enter in the police system of Italy without any kind of problem. So I asked myself, what can be is there any guarantees, any protection related to that? On the other side, El Pacto, which is considered very useful because, again, I'm not against a non-legal programs. On the contrary, they are a starting point for future negotiations. On the other side, I have the doubts that since they are non-legal instruments, they are also, again, overshadowing issues. And for example, one thing that they told me was that they are very happy about this networking of people, but we don't really know how do they share information. And it's possible that they share information without actually respecting the criminal guarantees that we all know. And then the last point that I want to make in general is the fact that Latin America is seen as a partner, of course, as a region, and with which we should collaborate, and I address for that as well. But I think we are seeing much more the will of cooperating with Latin American countries for a problem related to security rather than related to a will of ameliorating and improving the criminal justice systems. And with that, I'm just gonna thank you, Chloe. And if you want to contact us for more questions, we are available. Thank you very much.
Thank you very much, and sorry for the technical issues.
Thank you very much for your joint presentation and for sticking to time regardless of the technical issues at the beginning. So thank you very much, and also for having brought all our discussion and problems to the next level. That is not only within the European Union or European countries that is difficult, even more so at the next level when we broaden our view on the matter. So I think now we have some time for questions. We have already someone here in presence.
Thank you. I have yes, another question for me, but I think it's a great time to discuss a lot. So I use my rights to discussion. So I would like to ask two questions, but they are strictly connected with each other. To colleague Mirjak. Are you here? Because I don't see. Okay. So I have a question regarding what is, in your opinion, relation between rule of law and conception of Rechtsstaat. And the second one is that it is possible to implement rule of law in the systems when the legal judgment are not creating a law. In other words, they are not the source of law, but only may interpret it. Thank you.
Just a second. Thank you for your question. Well, I would say that it's very theoretical questions and maybe better for some constitutional lawyer. But definitely there is a link between the rule of law and the Rechtsstaat state being, and in one way, if some state is, it should be a state bounded by the rule of law. And I didn't get the second part. So what about the states that didn't, that have sources of law? Can you repeat again? Sorry.
So
probably
if you take that its connection between rule of law and Rechtsstaat, you don't provide me answer to the second question. Namely, in the legal scholars claims that rule of law stems from Anglo-Saxon legal order. So that order, when law is created by court as well. Rechtsstaat is a German conception created on the grounds of German legal system, where the law is created by lawmaker. So the law is such thing which is passed by legislator in appropriate form. So the rule of law are referring to some values which are beyond of legal text. So we have some collision between rule of law and Rechtsstaat because European law derive from common law systems. We have some common axiology, and there is a question how we may to balance the civil law perception of positivic law, right?
Okay, yeah, I get your angle. Okay, yeah, but you know that rule of law framework is of course being developed in the EU, and but that is of course it is kind of a reaction to all what is happening. So in the last decade and a half, with the deterioration of the rule of law in numerous member states, and of course it's even hard to define what rule of law is. And actually, this conditionality regulation is the first binding legal document that tried to do so in one of the first articles. But yeah, definitely, it's very important to know the difference. But yeah, I think it's a topic of its own, and maybe even for a thesis or a PhD topic itself. Yeah. But I just wanted to, in my presentation, to show that there is really an angle that EPPO is one of the institutions that is being more and more alert about the rule of law deterioration in member states, although it's not its task to do so. It's primarily up to the Commission, which is by definition of the EU law, the guarantor of the treaty. But yeah, I think this is also more some political science aspect as well.
Thank you very much. Is there any other question in presence or online, of course?
May I want to...
Please.
Niccolo, very much for your interesting presentation. If I understood correctly, you mean that we need also an administrative tool for the EPPO, or something before the criminal proceeding opening, or that was my there was a misunderstanding on that. I find this proposal very interesting. I don't know if you want to delve a little bit more on that, because of course in 10 minutes I know that you have to be
remarks. Thank you for the question. No, I mean, the problem is there are a lot of administrative instruments that de facto have the same effect of the criminal measure, but maybe they are more effective, but there are less rights. So the problem is that in the EPPO proceeding, there is difficulties to recover assets. So the problem is we have to look to the administrative procedures, or we can stand or follow the criminal path, the criminal way. I think that the criminal way is end up the better way. And from this point of view, my presentation is part of a project we have to, with University of Turin. Julia is one of our partners, and you can find all the deliverable on the website that I indicated in the last slide. That is Net for Few. We propose two tools. One is a risk alert software. The second one is the fast freezing order. So the first one is a software that could be useful for a fast signal of a suspicion transaction or a PIF offense. At the first things of PIF offense, the ADP could launch a very fast investigation, then freeze the assets just for 48, 72 hours, just to understand if the notitia criminis is founded, and then ask, order, request, depend on the national law, a preventive measure, a seizure, a freezing measure, but this is the point, more or less.
It's perfectly clear. So in order to leave space for criminal proceedings instead of administrative one. Okay.
Thank you.
Congratulations.
Thank you very much. Yes, please.
Thank you. So this question for Chloe and Benedetta. I think it was a wonderful presentation and super interesting. I was wondering if you, particularly Benedetta, you were able to delve a little bit more on this maybe unbalance that is presented between all the power that maybe these joint teams, for instance, the one of Italy and Brazil, have, and how the job of the defense lawyers it's carried out in those situations. Like you have defense lawyers in different parts of the world. Is there any dialogue among them? When these GITs are disclosed, and I mean, if you do know if there was any complaint on this as far as the rights of the defendant or defendants? Thanks.
Thank you very much for the question. And yes, like you got one of the points that I'm still trying to understand is the fact that we are trying to create this very interesting hub of like a joint investigation team, which is from the legal perspective, but even El Pacto is reuniting a lot prosecutors, so like judges and prosecutors, but what about the defense? And on that, there is not a lot to say, because the problem of the joint investigation teams, especially these ones, I'm really trying to find more, but these ones are really recent, and there is not more than what Eurojust is disclosing now. So I hope that going on with more news, since again it's just disclosed, there will be more informations, because the problem is the fact that during investigation everything is not disclosable. But this was a problem that was moved also for European instruments such as the EAO, which is the fact that for the defendant for the defense lawyer is much harder to get the informations. But it's an ongoing thing to see. And for the moment, again, there is only Italy, Brazil, but I'm not excluding that there is going to be Italy, Brazil, Argentina, for example, because there are many organized crime hubs that are in the region. But thank you for the question.
Thank you very much. Sorry. Is there any other question? Maybe I just use last minute to add on this, this last question, to ask also to Vannes, what are his conclusions in that sense from the Europol or European perspective? What conclusion do you draw? Do you drew them from the this concentration of information, accountability issue in terms of the defense perspective?
I think that we are currently facing a shift in that perspective. because I think over the past, or let's say 10 years ago, it was almost impossible to start a legal proceeding because of Europol's actions, whereas now we see that there are currently, I think, at least 4 cases pending before the General Court on the Sky ECC case. We also see that in national procedures, Europol is becoming much more involved, often as an expert, but with the newest competencies on the cooperation with private parties, it could turn out that there is a rise in procedures vis-a-vis Europol because of the requests that it can issue. So I think that the defense position will become a crucial element in the upcoming years, and it will be very important to see how it in the end turns out and whether national and European courts will be able to stand their ground against Europol.
Thank you very much. Okay, then if there's no other question, I thank once more our speakers for their great presentation, for having been with us in the Saturday afternoon, so sunny, and thank you all of you for having been here. Now I guess there is a coffee break.
Short coffee break, yes.
Okay, so.
And then we can come back at 6:45. There is the last panel. 4:45, sorry.
Thank you very much.
Hey, thank you for staying with us until the end. This is the last panel of this Young Penalist Symposium, the third panel on international cooperation, investigative tools, and prisons regulation in the fight against organized crime. The panel will be introduced by Luca Pressacco, tenure track assistant professor of criminal procedural law at the University of Trento, and will be chaired by Gaia Kaneschi, tenure track assistant professor of criminal procedural law at the University of Milan. So please, Luca, the floor is yours. Thank you for being with us.
Is it working? Yeah. Okay, so we have reached the final session of this huge conference. So that's great, and thank you to all of you for being present also at the very end of the conference. Firstly, I feel the obligation to thank another time the organizer, and especially Emanuele, also on my behalf, for the warm welcome at the Unitelma University, for the kind invitation, and for entrusting me with introducing this panel. It's a great pleasure to be here in Rome with so many talented friends and colleagues. Many valuable contributions have already been made, and I'm sure that the final panel will also provide some meaningful insights. This come, I would say, as no surprise, given the engaging topics that are covered by the speakers, not least because I felt, reading the abstracts, the commitment to examining effective tools for combating organized crime on the field, setting conditions for their legitimate use, respecting fundamental rights of the individuals targeted. The first area for consideration, it goes without saying, is international judicial cooperation another time, and I believe that its importance in a globalized world is beyond any reasonable doubt. So the first contribution focuses on the criminal phenomenon of money laundering. The speaker, Irene Antoci, who is present, will reflect on 2 aspects in particular. The first one, the need to develop common standards for the admission, analysis, and collection of digital financial evidence. I was wondering if this is a new evidence classification. And the second one, the need to improve and simplify the mechanism for international cooperation aimed at freezing and confiscating assets, including the virtual ones. Irene is a PhD candidate in criminal law at the University of Palermo, Department of Political and International Relationship, and also a trainee lawyer, strongly engaged in international criminal law, cybersecurity, and intelligence. Moving on, the second presentation shifts the focus from international cooperation to the procedural tools implemented by each country to tackle organized crime in a comparative perspective. So João Narciso, who is present, is not physically present, but online, connected, will focus on technological surveillance, discussing its potential and the risk involving the using of long-term secret surveillance measures. João is currently a PhD candidate in criminal sciences at the University of Coimbra, where he is also an invited assistant professor at the Faculty of Law. And finally, the last contribution concerns the treatment of prisoners convicted of organized crime offenses, an issue that certainly deserves more attention than it usually gets. The speaker, Ilaria Piccolo, will discuss the special detention regulation and the risk of violating the dignity of prisoners subject to special restriction, drawing inspiration from the Italian experience of the so-called hard prison. And more specifically, the attention will focus on the need to ensure that all the prisoners, including those detained for serious offenses, receive an individualized and suitable prison treatment for their effective rehabilitation. Ilaria holds a PhD in human rights from the University of Naples Federico II, where she is currently serving as a postdoctoral researcher and teaching assistant in criminal procedure, prison law, and juvenile justice. I believe I have provided all the relevant information, so now I turn the floor over to my dear friend and colleague Gaia Kaneski. Thank you for your attention, and I look forward to hearing the presentation from our panelists and panelists.
Thank you. Okay. Thank you. I wish to thank the organizer, especially Emanuele Birritteri, for his incredible work. And also for me, it is a great honor to open today's panel, which addresses a particularly urgent and complex issue situated at the intersection of criminal law, judicial cooperation, criminal policy, and prison regulation, the fight against organized crime, approached through the integrated lens of international cooperation, investigative tools, and prison systems management. In recent years, organized crime has undergone a profound transformation we all well know. From entities traditionally rooted in a local or national context, criminal organizations have now evolved into transnational networks capable of operating across borders and exploiting the infrastructure of globalization, systemic legal disparities, and the divergences among national legal systems. So these organizations now make use of sophisticated financial means and scripted communication networks and global logistical channels. Often they show a level of strategic flexibility and adaptability that surpasses the capacity of traditional law enforcement and judicial responsive. In this context, international cooperation in criminal matters is no longer merely a desirable asset, but a structural necessity. Combating and fighting organized crime today require advanced form of coordination between judicial authorities and law enforcement agencies. While there have been a lot of development, such as the introduction of the European Public Prosecutor Office, European Investigation Order, and various cross-border intelligence platforms, significant practical, legal, and I would say cultural obstacles remain. Cooperation is often hampered by bureaucratic inefficiencies, normative inconsistencies, and insufficient legal harmonization, especially outside the European legal space. I would have listened the paper of Naomi Gikuchi, but she is not here today. We have to focus on another space, the European legal space. And then now the effectiveness of criminal justice responses depends on the availability of adequate investigative tools. And then alongside the investigative and judicial dimension, there is in this session a third important and often underestimated aspect, the prison system. And the incarceration of many individuals affiliated with complex and hierarchical criminal groups do not in itself dismantle this organization. In many cases, prisons become spaces for the consolidation of criminal ties, recruitment of new affiliates, or even external command operation. Some jurisdictions have adopted special regimes. It's the case of Italy, Article 41 bis, for instance, and specifically aimed at serving communication between incarcerated individuals and their criminal networks. Yet, we have some question about this topic. How can security be inserted without infringe upon constitutional and international rights? How can repressive measures be reconciled with the rehabilitative aims of punishment? And what is the role of the prison system in a long-term anti-mafia strategy? And here I'm waiting for the answer of Ilaria Piccolo. At the same time, the prison environment can and must serve as a space for breaking away from criminal identities. But in this sense, penitentiary policy is an essential component of any coherent strategy against organized crime and cannot be regarded as an isolated or purely administrative sector, I mean. So, in the light of this short consideration, today's panels aims to address three key areas: the effectiveness and limitation of international judicial cooperation, the potential and legal challenge of advanced investigative tools, and then at the end, the role of the prison system. So the challenge posed by the transnational organized crime cannot be addressed through isolated or fragmented approaches. It requires an integrated strategy that combine rigor and guarantees, but efficiency and legality, repression and prevention. And most importantly, it requires critical and continuous reflection on our legal choices, judicial practices, and penitentiary policies. But I'm confident that the contribution of today's speakers will provide valuable insights in this direction. And I thank you for your attention. And I'll give the floor to Irene Antoci, University of Palermo, for the first presentation, Money Laundering and Organized Crime, Procedural Challenges and the Role of International Cooperation. Thank you.
Good afternoon. Thank you for introducing me, and thank you to Emanuele, to all the staff. This is the first time that I speak in an AIDP conference, and I just arrived in the big family of young panelists, so I'm really glad to be here. So today I'm honored to address a topic that is central to the contemporary fight against organized crime, which is the nexus between transnational organized crime and money laundering, and the ways in which digital finance is reshaping this relationship. Money laundering is not merely a financial offense. It constitutes the operational backbone of organized crime. By legitimizing illicit profits and reinvesting them into lawful markets, criminal networks sustain their activities, ensure durability, and expand their political influence. Traditionally reliant on cash, shell companies and offshore accounts, laundering now increasingly exploits cryptocurrencies, decentralized finance, and other digital instruments. So this evolution challenges national and international authorities in detecting, investigating, and prosecuting these crimes. I'll give you some numbers. Money laundering is a systemic global phenomenon. According to the United Nations Office of Drugs and Crimes, from 2 to 5% of global GDP, between 800 billion and 2 trillion USD, is laundered annually. These funds allow criminal organizations not only to profit, but also to survive and expand. By infiltrating legitimate markets such as real estate, public procurement, banking, illicit funds distort competition, inflate prices, and erode public trust. So EU agencies, including Europol and the European Public Prosecutor's Office, emphasize that money laundering frequently overlaps with fraud against EU financial interests, highlighting its systemic threat. Digitalization has profoundly changed laundering techniques. Traditional schemes are increasingly replaced by crypto-based tools, privacy coins, tumblers, mixers, and decentralized exchanges. So criminal networks exploit blockchain pseudonymity to transfer funds across borders almost instantly. Cybercrime now converges with traditional organized crime. Ransomware, online fraud, cyber extortion often feed into laundering networks alongside proceeds from trafficking or corruption. So regulatory gaps, especially among virtual asset service providers, compound these procedural and technological challenges. I took in consideration Italy because Italy offers a particularly instructive case study due to its long experience with mafia-type organizations. Italy has developed a sophisticated legal and institutional framework. We've already talked about Legislative Decree 231 of 2001 that introduced corporate liability, criminal liability, encouraging companies to adopt internal compliance models, preventive confiscation, but also institutions such as Direzione Investigativa Antimafia, the Financial Intelligence Unit, coordinate investigations domestically and with European partners. However, challenges persist because, as Dr. Recchia noted this morning, before discussing organized crime, it is essential to define it. A useful reference actually is the framework decision of 2008, the number 841, which defines an organized criminal group as a structured association of more than two persons, existing over time, acting together to commit serious offenses, punishable by at least 4 years of imprisonment, to obtain financial or material benefits. A structured association does not require formal roles, continuous membership, or a complex hierarchy. It must simply not have been formed randomly for the immediate commission of that crime. Actually, Article 6 of the EU Directive of 2018, number 1673, considers the following as aggravating: where the offense is committed within the framework of a criminal organization as defined in the framework that we have been talking about. So here lies a key challenge. Italy already recognizes the aggravating circumstance of the mafia type method under law number 203 of 1991, targeting the intimidation and coercion typical of such organizations. However, this does not automatically cover organized crime or money laundering committed by non-mafia groups. So at the national level, solutions could include maybe or introducing a specific aggravating circumstance for offenses committed within a criminal association, organization, or maybe including money laundering among the aggravating factors under Article 416 of the Italian Criminal Code. Another important topic, in my opinion, is the evidentiary complexity in the digital age. Because today, proving the criminal origin of funds is increasingly complex. Multi-tier structures, offshore entities, intermediaries, obscure ownership. So cross-border cooperation can be slowed by procedural divergences. Digital assets exacerbate these challenges, as fragmented and anonymized transactions complicate traceability. Also, preventive confiscation is effective, but raises constitutional concerns. The European Court of Human Rights highlights the need to respect the presumption of innocence and property rights under Article 6 and Protocol 1. So confiscation must therefore remain proportionate, transparent, and judicially supervised to avoid preemptive punitive effects. In my opinion, one thing is sure, that no state can combat money laundering alone. UN conventions, European investigation order, joint investigation teams, and coordination via Eurojust and Europol straighten cross-border investigations. The European Public Prosecutor's Office focused on the EU financial interests and directly addresses laundering linked to fraud and corruption. So challenges persist due to fragmentation because we have inconsistent legal definitions, divergent evidentiary standard, and issues of double criminality hinder effective cooperation. Actually, we see a small light because the 2024 EU AML package introduced the Anti-Money Laundering Authority, AMLA, and the Single Rule Book, aiming to harmonize supervision and enforcement across member states. AMLA will issue binding guidelines, coordinate investigations, and support the financial intelligence unit and law enforcement. So this could facilitate faster asset freezing, more effective cross-border tracing, and procedural consistency. The Single Rule Book establishes uniform standards for customer due diligence, beneficial ownership, and reporting obligations, reducing regulatory fragmentation and enhancing legal certainty. So it will act as a central hub for intelligence and best practices, and it will strengthen integration among national authorities, Eurojust, Europol, and European Public Prosecutor's Office, improving in this way Europe's capacity to tackle sophisticated transnational laundering, including digital finance and crypto assets. So, in my opinion, key priorities include, on a side, procedural innovation and harmonization. On the other side, enhanced cooperation, obviously always safeguarding fundamental rights. preventive measures should remain proportionate and judicially supervised, preserving the rule of law. And in conclusion, even this incomplete transposition of the EU Directive number 1673 and the Article 6 in particular on laundering by organized groups remains a critical weakness. Full implementation of this directive will strengthen Italy and align domestic law with the European Single Rule Book. So, in conclusion, this is a borderless phenomenon, as we all know, and in my opinion, it requires harmonizations of laws, procedures, and cooperation, because only through such integration can criminal financial networks be dismantled. And in this way, we can safeguard justice and freedom even in this hard digital era. Thank you for your attention.
Thank you, Irene Antoci, for your brilliant presentation. So let's go on with João Narciso. João
Good
Narciso
afternoon.
is online. Okay, João, good afternoon. University of Coimbra, he will discuss a paper titled Long-Term Surveillance as a Dual-Purpose Measure in the Fight Against Organized Crime, the question of convergence between criminal prosecution and prevention. João, the floor is yours.
Hello, can you listen to me?
Yeah,
Okay.
we can also see you.
Thank you very much. I would like to begin by greeting all the professors and the colleagues attending, both in person and online, and by expressing my gratitude and congratulations to the Young Penalist Committee for organizing yet another symposium. The topic of my presentation is long-term surveillance, also known as planned and prolonged police monitoring, a highly significant measure in the fight against organized crime, which serves a dual purpose, namely both criminal prosecution and prevention. To outline my presentation, sorry, I have to correct. Okay. To outline my presentation, I will begin by framing and contextualizing long-term surveillance. I will then identify the fundamental rights that are restricted by this measure, determine whether it has a legal basis under Portuguese law, and depending on that conclusion, address the question of whether the evidence obtained through it can be used in criminal proceedings. Finally, based on the discussion, I will offer some concluding remarks. The fight against organized crime requires, due to the growing need for security, the strengthening of state powers, both in terms of repression and prevention. However, since it is an intensive form of criminality, in order to deal with the ways in which it appears, in recent years we have seen, on the one hand, the use of non-criminal tools to combat organized crime, and on the other, means that can serve both preventive and repressive purposes. With regard to the latter, one of the measures most commonly used by the police is long-term surveillance. Although in some legal systems this kind of surveillance is
João, we cannot hear you.
Maybe you have closed the microphone. We lost you a few seconds ago.
Sorry, wait 1 minute. Maybe we have a problem here in Rome.
Yes, but here it seems that everything is okay.
Okay, we are fine. Go on, please.
Okay. However, these police surveillance activities have the same practical relevance as other covered investigative methods in criminal proceedings.
Sorry, once again, we cannot see your slide. We cannot see your presentation.
Okay, maybe it's better to try without PowerPoint. And now, is everything okay with my sound?
Yeah.
Okay, I will try without presentation.
Okay. Thank you.
Long-term surveillance can be defined in contrast to short-term surveillance as planned and discrete monitoring that extends over more than one day and enables a comprehensive understanding of the individual's living conditions. In addition to this temporal dimension, there is often a technical one. Observation measures are not necessarily limited to visual surveillance, as they are frequently combined with the use of technical or technological means. What is certain is that surveillance may take place both for criminal repression and for criminal prevention purposes. On the one hand, within the repressive field, that is, in the context of criminal proceedings, surveillance aims to identify those involved in the commission of a crime, to obtain evidence, or to prepare an arrest.
Sorry. There is a problem with the... Okay. Try to talk, please. No. No. Just 1 minute. Wait, please. No. Okay, so Joao, we go on with the next presentation and then we try again with yours. Sorry.
Okay.
Okay. So now we have the last. She's not the last. And we have Ilaria Piccolo, University of Naples, Federico II, Organized Crime and the Constitutional Phase of Punishment. Thank you, Ilaria. The floor is yours.
Thank you. I thank Professors Pressacco and Kaneschi for the introduction, and I want to thank to the organizing committee for this opportunity. So in these minutes, I will focus on some recent reforms in Italian prison law. I chose this topic because prison treatment, together with the criminal law, directly contributes to the fight against organized crime. I start with a consideration. As Michel Foucault wrote in the opening pages of Discipline and Punish, today the state no longer punishes through public torments, but through the denial of rights otherwise granted to the general prison population. So I would like to refer to a legislative reform and a recent court ruling to show how this technique of depriving rights often emerges in the fight against organized crime. However, this technique often reflects not a real concern for security, but a symbolic use of penitentiary law. To understand the logic behind the prison treatment of persons convicted of organized crime, we must start with Article 4 bis of the 1975 Penitentiary Act. Of course, as has already been said yesterday and today, there is no clear definition of organized crime offenses, but however, criminal, mafia, terrorist associations surely fall within the scope of this Article 4 bis. that was introduced in 1991 precisely with the aim of fighting mafia crimes. In essence, this Article 4bis establishes that for those prisoners, the execution of the sentence is stricter. To obtain prison benefits, person convicted of organized crime must prove a series of conditions that are almost impossible to demonstrate. One example is the condition that requires proof of the impossibility of restoring any relationship between the prisoner and the criminal organization. In other words, the law requires proving that something will never happen, so you understand something that is very hard to demonstrate. But I would like to focus on a different point. Among the elements considered positively for obtaining prison benefits, there is also participation in restorative justice programs. And this is an interesting point because a 2024 Italian reform has expressly prohibited prisoners held under the strict regime of Article 41bis from taking part in restorative justice programs. Alfredo D'Alise has mentioned in this morning's session this reform. It may be important to clarify the relationship between Article 4bis and 41bis of Penitentiary Act. In essence, a prisoner convicted of organized crime certainly falls within the scope of Article 4bis, and therefore access to prison benefits is more difficult. But if there is also suspicion of present links to the association, in addition to Article 4bis, the hard regime under Article 41bis also applies. And this provision lays down a series of rules, including, as I said, the total exclusion from restorative justice program. Now, if we compare Articles 4bis and 41bis, we realize that there is a contradiction, because on the one hand, Article 4bis includes restorative justice as a positive factor to be considered in granting benefits. And on the other hand, Article 41bis absolutely excludes the possibility, the same possibility, for those under that regime to take part in restorative programs. So, restorative justice is first presented as a tool to overcome barriers to prison benefits, and then at the same time, it's completely denied to those considered most dangerous. But why? Why completely exclude a case-by-case approach? Probably because restorative justice in Italian system can lead to some benefits and sentence reductions. And so this exclusion sends a powerful message that for some prisoners, no formal benefits can never be contemplated. The same logic, and I'm talking about the logic of depriving rights, can also be found in recent case law. For example, in the topic of the right to emotional relationships in prisons. Despite some progress in recognizing prisoners' rights, when the offense involves organized crime, it's more difficult to move forward. In recent years, there has been much debate about recognizing the right of prisoners to maintain emotional ties while serving their sentence. And for adult prisoners, the Italian legislator has continuously ignored such claims. For this reason, in 2024, the Constitutional Court decided that prisoners must be allowed private visits with their partners without visual supervision in prisons, inside prisons, when there are no security concerns. The court identified clearer rules for prison authorities and supervisory judges to apply immediately. But this step is relevant because, once again, prisoners under Article 4bis of Penitentiary Act, so prisoners convicted of organized crime offenses, are excluded. This means that those prisoners can never ask to meet their partner in prison, even when there are no dangerousness reasons to justify the exclusion, no matter the individual's contribution to the case. The abstract title of the offense somehow prevails over all the requirements of the specific case. So I'm coming to my conclusion. Denying access to restorative justice or refusing the right to intimate relationships in prisons are intentional legislative and jurisprudential choices. They respond to the technique of depriving rights that I mentioned. But the compatibility of this approach with the Italian Constitution remains highly questionable. The Italian Constitutions, in various provisions, but Article 27 above all, enshrines the principle that punishment cannot entail superfluous suffering. Anything that is not instrumental to the rehabilitation of the convicted person is unnecessary and therefore unconstitutional. The Constitution makes no distinction based on the type, on the abstract type of the offense. This means that punishment cannot be designed as an abstract opposition to organized crime as a phenomenon, a general phenomenon, but should be based on the assessment of the individual, because behind every offense there are countless human stories that deserve to be valued in their own right. Because out of 1,000 people, perhaps 999 will their request rightly rejected. But the law exists also and above all to protect the right of that one single person. Thank you.
Thank you, Ilaria, for your important and right, in my opinion, focus on prison law, an often underestimated sector of justice. Come back with Joao. Joao, are you with us? Joao, now we can hear you. Okay. There are some questions.
Waiting for Joao to join. Maybe we can collect some questions if you're okay. Joao.
Okay. Joao, now
Can you hear me? Can you hear me?
Yeah.
It's Isabelle. It's just to check if it's only his sound or anyone's sound.
No, it's
Can you
okay.
hear
We
me?
can hear you, Isabel. So
Okay.
our audio should be okay. Joao, try now. It isn't working. Sorry. Do you have another device? Plus one, because our audio is okay. So I don't know how we can help you. Just 1 second. Okay. Do you have a phone? You can try using your phone because our audio is okay. We can listen to Isabel and the other joining online. So our audio is on. If you can try with there is time, don't worry. If you can try to log in with your phone or another device, because it seems that your computer is not working. You can write in the chat if you want, or by email.
Now you're muted, João.
And now.
Okay.
Now we can listen to you.
Okay, I'm so sorry. I will try for another one.
No problem. Joao, if you want to start from the beginning.
Okay. The topic of my presentation is long-term police surveillance, also known as planned and prolonged police monitoring, a highly significant measure in the fight against organized crime, which serves a dual purpose, namely both criminal prosecution and prevention. To outline my presentation, I will begin by framing and contextualizing long-term surveillance. I will then identify the fundamental rights that are restricted by this measure, determine whether it has a legal basis under Portuguese law, and, depending on that conclusion, address the question of whether the evidence obtained through it can be used in criminal proceedings. Finally, based on the discussion, I will offer some concluding remarks. The fight against organized crime, due to the growing need for security, requires the strength of state powers, both in terms of repression and prevention. However, since this is an intensive form of criminality, in order to deal with the ways in which it appears, in recent years we have seen, on the one hand, the use of non-criminal tools to combat organized crime, and on the other, means that can serve both preventive and repressive purposes. With regard to the latter, one of the measures most commonly used by the police is long-term surveillance. Although in some legal systems this kind of surveillance is incorporated in criminal procedure codes, in Portugal and in other jurisdictions it seems to be a legal vacuum. However, these police surveillance activities have the same practical relevance as other covert methods of investigation. Not only have police agencies always carried out these activities, but the evidence obtained from it is often admitted in court. Long-term surveillance can be defined in contrast to short-term surveillance as planned and discrete monitoring that extends over more than one day and enables a comprehensive understanding of the individual's living conditions. In addition to this temporal dimension, there is often a technical one. Observation measures are not necessarily limited to visual surveillance, as they are frequently combined with the use of technical or technological means. What is certain is that such surveillance may take place both for criminal repression and for criminal prevention purposes. On the one hand, within the repressive field, that is, in the context of criminal proceedings, surveillance aims to identify those involved in the commission of a crime to obtain evidence or to prepare an arrest. In essence, it is a method of investigating facts of criminal relevance. On the other hand, within the preventive field, surveillance occurs before any knowledge of a crime exists. It is carried out to detect the preparation of criminal acts or to monitor individuals or groups from where there are reasons to anticipate future involvement in unlawful activities. In short, for the pursuit of police and internal security objectives. However, while it is true that in classical terms there was a clear separation between criminal repression and prevention, today there is a convergence between criminal prosecution and the prevention of dangers. And one of the factors contributing to this blurring of boundaries is precisely the use of covert methods of combating organized crime, such as long-term surveillance. This question is of particular importance given that this kind of surveillance is currently included in the scope of dual-purpose measures. In other words, it is a measure that, in a specific case, can be used both for prosecute criminal crimes committed in the past and to prevent future crimes. This gives rise to practical concerns, including which purpose prevails in a specific case and whether data collected for preventive objectives may be used for prosecutorial purposes. As for the data collected, the execution of this kind of surveillance makes it possible to gather a wide range of information concerning the movements, habits, relationship, routines, and the schedules of the persons under observation. From this, it is possible to create an almost complete image of their movements and habits and a highly detailed knowledge of their lifestyles. It follows that long-term surveillance primarily restricts the right to privacy, although the degree of interference may vary considerably. On the one hand, the level of intrusion is more severe when technical means are used, such as sound and image recording, since this also entails violations of the rights to one's image and to one's spoken words. Finally, the right to informational self-determination is also restricted. This right has been described as the right to withhold from public knowledge facts and behaviors that reveal the way in which an individual conducts their private life. In Portugal, there is neither an explicit nor an implicit reference to long-term surveillance in the Code of Criminal Procedure or in any other legislation. It may be therefore concluded that, unlike what occurs in other European legal systems, Portuguese criminal procedural law is entirely silent regarding the regulation of long-term surveillance. Despite the omission of the Portuguese legislator, a review of the Portuguese case law shows widespread judicial acceptance of long-term surveillance. Firstly, surveillance reports are often used in court hearings. Secondly, in many cases, surveillance leads to the use of other evidence-gathering methods, such as telephone interceptions, as well as the implementation of coercive measures and detention. However, since criminal procedural law does not regulate the use of this covert investigative method, and given the significant intrusion into the right to privacy and the right to informational self-determination, a dual conclusion must be reached. On the one hand, the execution of long-term surveillance constitutes an abusive interference with private life. So, in accordance with our legal framework, this can only lead, on the other hand, to the nullity and non-admissibility of the surveillance reports and witness testimonies derived from it. To overcome this obstacle, the legislator must first clarify the situations in which long-term surveillance may be used for preventive purposes or for gathering evidence in criminal proceedings. For preventive purposes, this should be addressed in police legislation, and for repressive purposes, it should be specified in the Code of Criminal Procedure. With regard to Portuguese criminal procedural law, following the example of other legal systems, a legal framework for long-term surveillance must be established. First, the temporal and spatial scope of the surveillance should be defined, along with whether the use of technical or technological means is permitted. As for the material requirements, it is necessary to clarify the list of criminal offenses, the degree of suspicion required, subsidiarity, and the subjective scope of the measure. Concerning the organizational requirements, it must be determined which authority is competent to order the measure, public prosecutor or judge, the minimum and maximum limits, and any other possible extensions. All this must be done without forgetting a proper balance between the need to combat organized crime and the protection of fundamental rights. My presentation is now complete. I have to apologize for the technical problems and thank you all very much for your attention.
Thank you, Joao. Question and answer. Yeah.
There are questions? No,
It's too late. Oh, okay.
Thank you. I have a question for Ilaria Piccolo. You mentioned the Italian Constitutional Court's pronunciation on the right of prisoners to have a private conversation. And actually, the Constitutional Court did not stating on the point related to special regimes, ruling stating that the provision of the ruling could not be extended to special regimes because the case before it did not concern special regimes. And the court said that in those cases, other requirements would have been balanced. So my question would be, in your opinion, do you think that this balance is possible? And if you think yes, how? Thank you.
Thank you for the question. So in few minutes, and the issue is complex, so I'll try to do my best for my answer. You mentioned intimate conversations, but Constitutional Court, the ruling is number 10 of 2024, is about really intimate situations in prisons, not only conversations, for precisely. So I think that important is to make a difference between hard regime under 41 bis, and I can share with you your point of view that in that case there are some security concerns that probably prevails on the, I think not always. The problem is the absolute preclusions, because the absolute preclusions are linked to the offense and not to the person. But I think that the importance is to make a distinction between hard regime and Article 4 bis, because Article 4 bis are the ostativity offenses, no? Also the 416 bis mafia offenses in Italy. Not all those prisoners are under 41 bis regime. So my reflection was concerned the prisoners convicted of offenses that fall into 4 bis. And I don't know if I'm clear in my answer. I think that you touch a very crucial point, no? The balance between security concern and the right. Yes, in the practice is completely different, because the Constitutional Court declared that the Article 18 of a Penitentiary Act is unconstitutional, but in the practice is completely different. But I think as a jurist, we have to reflect, we have to underline the importance of exclude the absolute preclusions from our laws in penitentiary. For example, for minors, in legislation for minors, I think that the legislator, the Constitutional Court, makes some right choices. For example, the Article 4 bis is unconstitutional, totally unconstitutional for minors. And I'm not agree that if a person makes 18 years old and 1 month is subject to another story, another prison treatment that is an old-fashioned punitive treatment, I think, very far from Article 27 of the Constitution. I don't know if I have a response to you.
I agree with your point of view. I'm just like provocating, because this is the main argument that is raised in these cases.
Yes, but I think that the security concerns cannot be valued in absolute way, against the offense in a generalization, I don't know, and not for the linked to the person. Probably for 41 bis, okay, but I don't agree with absolute preclusions. For sure, this is the theory, and the practice is completely different.
Yeah, thank you.
But thank you.
Thank you very much for the very interesting presentations. I have one question for Irene. It is most out of ignorance. I was interested in the relation or the competencies of the anti-money laundering agency concerning freezing of assets. What would be the role of the anti-money laundering agency in the freezing of assets within the European Union, and whether it has some specific powers, or in regard also to, for instance, the regulation and the mutual recognition of freezing and confiscation of assets. What is the role of this agency within the broader context of asset recovery within the EU? Thank you.
Okay, so it's a subject that they are still thinking about, because I was in a conference in Brussels some weeks ago, and I was listening to the president of AMLA, and she was saying that they are still thinking about it. What is sure is that they will coordinate national authorities, taking from every state the different institutes that they have in every state. So, for example, they will stay upon confiscation or the modalities of freezing assets in every state. So they will not use a unique strategy. They will borrow every institute from every state.
I have also a question for Irene. First of all, thank you for your presentation. It was very interesting. I was wondering, since you addressed the two different problems, on the one hand, the lack of an harmonization, and on the other, the problem of guaranteeing in an adequate manner fundamental rights, don't you think that the same definition of organized crime that you quoted is a bit outdated, or better, not outdated, but it doesn't take into consideration the actual manifestation of organized crime, since because of the reference of two components. In other definitions, the reference is three, but do you really think that it suffices just 2 or 3 persons to speak about an organized crime, enabling invasive procedures like the application of anti-money laundering directives or freezing confiscation orders? Thank you.
So you're asking me if it's not enough, that definition anymore, if it's antique.
I'm asking you about the adequacy of referring to just 2 components to have an organized
two persons.
organizations. Yes.
Well, I think we always have to look at the empirical situation. So probably is not enough anymore. But it depends on the dimension of the organized crime. It depends where it is, because there are different organized crimes that cannot be, I don't know how to explain, that can be different in different places. So that definition has the aim to be an umbrella, but then we cannot stay far away from the empirical situation. So it depends. It's a long story, in my opinion. Yeah, we should talk a lot about it.
So maybe, it's just a curiosity. Joao, can you hear us? Yes, I think
Yes.
so. I was just wondering, you mentioned that long-term surveillance measures are very often used and admitted in court in Portugal. And I was just wondering if there is some sort of legal basis for using these measures, at least in a provision stating that means of evidence that are not specifically provided are anyway admissible in court under some conditions, like this is the situation of the legislation in Italy. So I just wanted to know if there is some sort of legal basis or it's just something that is coming from the practice. And the second observation is for Ilaria. Do you think that the jurisprudence of the Constitutional Court on absolute preclusions in preventive measures, especially in preventive detention, we have a well-established caseload on absolute presumption that were ruled out by the Constitutional Court, could be a source of inspiration also for the Prison Acts? Thank you so much. to both of you.
Thank you very much. Regarding to Portuguese criminal procedural law, we do not have a legal basis for long-term surveillance. What happens regarding the use of evidence collected in criminal proceedings? In our system, we don't need a legal basis to use such kind of reports about the surveillance in trials as evidence. However, since this kind of measure constitutes an abusive interference into the private life and other rights of the persons under observation, if we are rigorous with the principles of our legal system, it is necessary to have a legal basis regarding long-term surveillance, define the conditions under which it is mandatory to require.
Thank you, Joao. Thanks.
Thank you for the question. So I think, yes, the jurisprudence of Constitutional Court had made a great work to eliminate absolute preclusions. I mentioned, for example, the ruling of 2019, if I don't make a mistake, that excludes the entire article forbids for minors, but there are a lot of rulings that we can mention. But for this reason is interesting, the ruling that I mentioned about the effectiveness in prisons, because this sentence demonstrates how, when the crime involves organized crime, it's more difficult also for the Constitutional Court to make a step forward, no? It's difficult, and also the Constitutional Court repeats the logic of denial rights to make the punitive treatment, no? So yes, it could be an inspiration, but I think that when the offense involves organized crime, even for Constitutional Court, for our Constitutional Court, it's difficult to make a very re-educational treatment in practice.
Thank you. It's late. So I don't know if someone want to make another question. No? So thank you. Thank you. And we close this panel. Thank you.
Just a few last words. First by Isabel, are you there? The president of the Italian of the Young Penalist Committee. So thank you very much for staying with us until the end, and the floor is yours for the concluding remarks.
Thank you, Emanuele. Good evening, everyone. We've reached the end of our symposium. I'm so sorry I couldn't be there with you in person in Rome, but I was here listening to all the presentations. First of all, I would like to express my deepest gratitude to the University of Rome, UnitelmaSapienza, and to the Italian group of the AIDP for so kindly hosting us in Rome. Your hospitality and support have made this event possible. I would also like to extend my gratitude to Emanuele Birritteri, my colleague from AIDP Young Penalist Committee, for his extraordinary commitment in organizing the symposium. My sincere thanks also go to the professors who were kindly agreed to introduce and chair the panels, even on a Saturday, and to Professor Katalin Ligeti and Professor Stanislav Tosa for their invaluable contributions through their keynotes and opening speeches. And last, but certainly not least, to all the young panelists who submitted their papers and presented their research over these 2 days. Thank you. I'm absolutely delighted with the outcome of this symposium. Over these 2 days, we have traveled through an extraordinary range of discussions, from non-conviction-based confiscation to corporate liability, environmental crime, digital justice, and international cooperation. Each session has revealed how the fight against organized crime continues to evolve, constantly balancing between tradition and innovation, just as our team so aptly proposed. It has been truly inspiring to see almost 50 young panelists from different countries participating, many of whom traveled all the way to Rome to share their ideas and perspectives. And it's interesting to remember that this event was originally planned as a one-day symposium. However, the number and quality of the submissions we received were so impressive that we decided to extend it to Saturday as well. And I must say that was probably the best decision we could have made. The main purpose of this symposium series has always been to foster a community of young panelists around the world and to encourage the production of high-quality research. And after these intense and insightful discussions, I'm confident that we are achieving precisely that. And looking ahead, as Aliti Giannini mentioned earlier, I'm very happy to announce that the next AIDP Young Penalist Symposium will take year on the 9th and 10th of April at Utrecht University in the Netherlands. The symposium will be jointly hosted by the Netherlands National Group of AIDP, the Young Panelists of the group, Maastricht University, and Utrecht University. The theme of the symposium will be criminal law in the age of transitions between sacred cows and core values of criminal justice systems. The event will explore how global crises, technological transformations, and shifting political realities are reshaping the very foundations of criminal law. And the symposium will invite young panelists to reflect on the evolving role of criminal law at national, supranational, and international levels. So we invite the submission of abstracts that may address topics such as constitutional and legal foundations in transition, social and political challenges to criminal justice, the evolving role of actors in criminal justice, and environment and sustainability in criminal justice systems. So next week, we'll be releasing the call for papers. Please follow our social media channels for updates and start preparing your abstracts. So thank you once again to everyone who made this symposium such a success. And I look forward to seeing you all again in Utrecht next April for another inspiring edition of the AIDP Young Penalist Symposium. Thank you very much. And to those in Italy, enjoy your time in Rome.
Thank you very much, Isabel. Also from my side, some last few words. Greetings for you, and thank you for staying with us until the end. Just a few words. I have to say that all the presentations, in my view, fully met our expectations, I have to say. Interesting insights has emerged, which I hope now we will be able to develop further in the publication of the proceedings. So we have a hard work in front of us already. I have to say that in our call for papers, we tried to outline a number of research lines that we found particularly compelling. And I have to say that many points we had suggested in the call for paper have been addressed by the young panelists in a great and an original manner. Of course, this has been a very long journey, two very long days, but I think we can be happy of the results of this symposium. I have to say just three last points, the main topics that have emerged in my view. First, the tendency of several legal orders to respond to organized crime not only with traditional tools of criminal law, but also with hybrid and formally non-criminal measures. That's something that we should develop in the book of proceedings, in my view. The second point, the result-oriented approach in the fight against organized crime. So the tendency of several jurisdictions of focusing more on efficiency of enforcement tool, perhaps sometimes with less adequate safeguard and with less attention on focusing also in protecting fundamental rights. The third one, in my view, is the evolving nature of organized crime, operating not only within the legal markets, but also trying to integrate into the legal economy. And fourth, the role of international cooperation and the EU in the fight against organized crime. And also from this side, we saw that there are links with the other main lines of the research, that we will try to develop next. So, of course, as you already heard, this event is not an isolated occasion. We have a 5-year cycle from 2024 to 2029 until the next International Congress of Penal Law. We will try to organize an international symposium of young penalists at least once a year. So if you are not already part of the AIDP, join the AIDP, because in doing this, you can be always updated with all our events. You already heard about Utrecht next year in April, so present your papers, try to be part of this wonderful group that is the AIDP. And so from my side, it's all. Thank you very much for staying with us until the end. Long live the AIDP and long live the young penalists. Thank you very much.